Hey, what's up, guys? Welcome to Law-Splaining the Interwebs. I am your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota, and I am back in the vault. And it is good to be back in the vault. It is good to be home. I don't know about you guys, but I always love coming home. And I'm still fending off this throat thing, but I can now lubricate with a nice thing of Milo's. And some whiskey. And we have a transcript today. We have a transcript of this hearing. This hearing took place back in November. What day was it? The 21st day of November. The transcript would have been requested, I don't know, probably on the 22nd or something like that. We're talking a rather sizable delay in the production of this transcript. But, you know, it's a combination of a lot of things. You had Thanksgiving, you had Christmas, shouldn't have gotten that long. I believe there were some other things that hit the court at the time that just required the work of the court reporter slash transcriber, and they just couldn't get it done. They just had things to do. But that's annoying for the rest of us in the world who want to see the thing that you're supposed to be having done, right? Oh boy. There was Hanukkah too. Yes. But we now have this 190-page monstrosity, and we're going to go through it. I don't know that we're going to get through all of it today, because them's a lot of pages. And, you know, this hearing was like 5 hours long. And I think reading through it, even at a good clip, is going to take several hours. And that leaves out any sort of commentary. So we'll just see how it goes. We'll just see how it goes. We'll get where we get. We will enjoy the laughs. There are some laughs in here. There's a lot of references to moi. There's a lot of references to the GoFundMe. There's a lot to talk about and a lot to cover. But this will help us get to the logic behind Judge Chupp's ruling. Sort of. I mean, we'll have to still speculate and guess at his logic, as he has yet to produce. Excuse me. I took cough medicine, so it should be kicking in any time now. But he has yet to produce his findings of fact and conclusions of law. Technically, I believe he has until the 5th, which falls on a Sunday, so it should give him until the 6th to produce those. And then if he doesn't produce those, Lemoyne can whine to the appeals court about it, which they already have appealed it. So there might be some motivation for Chupp to just not do it, right? It doesn't matter what he says. They're going to appeal what he says anyway. So he may just not do it. And there's not much they can do about it other than, like I said, to just go ahead and add it to the appeal that he didn't include a findings of fact or conclusion of law, and say that it was an abuse of discretion and all of that stuff. And then naughty Chupp bad. Remember how much they loved Chupp. Now they're like, this guy's not doing what we want him to anymore. Now he's not the beloved Chupp of old. So I'm gonna kill a little bit of time here as people are filtering in, because I know that a lot of people have been waiting to see this particular document, and we're gonna go through it. So in the meanwhile, let me clean up a couple things. Excuse me. As I said, I've been fighting off an illness for a good while now, about 2 weeks. It's lovely. When winter comes in Minnesota, it hits hard, and then illness follows. So that's great. Let's address some things here. Yes, I have seen Senpai's video. He seems very upset that I talked about our conversation about him coming on my show and represented it. He calls it a misrepresentation of him, in which he asked me to be on the show. And let's unmisrepresent this as much as possible, because a long time ago I said I would have him on the show in May, something like May 5th, right before a bunch of documents were filed that no one really expected in relation to the depositions. And I said I would have him and several other people on, and I ended up having approximately none of them on. Maybe one, I don't know, but I didn't get to any of them. And so Senpai came back and said, hey, when are we going to do the show? You said we'd do a show. And I asked him to pitch me a show, because I don't know his work or what he does. I don't watch a lot of YouTube, and I don't watch a lot of YouTube related to the Vic case, because I kind of have the Vic information that I need. So it's not personal. I just don't watch much of it. And I've watched none of his stuff other than his most recent masterpiece. Anyway, so I said, I'm not familiar with your stuff. I don't really know. I don't know what we're going to talk about. Pitch a show. He pitched a show, and in the next paragraph was, in my opinion, bitching and whining about me keeping my word, as if he has some right to be on my show, which he does not. But I was happy to do a show with him. I don't think we're going to now, because I don't think that there's much use in doing that. And there's just, I told him that one of the reasons I didn't have him on before is because I wasn't interested in some drama thing he got involved with some chicks. That, whatever. I don't know what it was, and I'm not interested in it, so I don't care. Again, not personal. I'm not condemning or condoning the drama. That's all yours, buddy. I just don't care, and didn't then, and I don't now. And so, yeah, I'm done with it. I hope that unmisrepresents things enough for you. I don't know how else to be honest. He said I would lie about a group chat I was in with him on Twitter. No, why would I lie about that? I was in a group chat with several, quote, I stand with Vic YouTubers on Twitter. Because shockingly, YouTubers who are covering the same things sometimes talk about the things that they're covering. And I guess because of that, I was supposed to have been familiar with his content or something. I don't know. I don't follow the logic. Doesn't bother me. So that's why he's mad, because I was dealing with him bitching at me and whining in my perspective, right? And so I talked about it because someone asked me about it. So there you go. That's that. So anyway, and I left that group. Oh, and to the mysterious, why was the group deleted? But I'm so glad that he saved everything. I didn't delete the group. I can't. That Twitter account got banned. It got banned. If you want to know why you can't access those messages, it might be because that Twitter account got banned. But because it got banned, I can't do anything to the group texts that are there. So I don't care. What a weird... weird thing to come up. Anyway, so yeah, we'll just probably not have, we'll just, let me uninvite Senpai from the show officially, so there's no more misleading of anybody or anything. I really did intend to have him on at some point, and things got away from me. There are actually a couple other YouTubers who I believe I mentioned having on the show at some point, and if I haven't gotten back to you about coming on the show, you know, and you want to come on the show, remind me. I'm not opposed. I just got really, really busy covering a whole bunch of stuff. And you can go back and watch me say over and over, things should be slowing down about now. Things will probably slow down soon. Things might slow down. And being consistently baffled by how much activity was going on. And as we'll see in this transcript, the judge is baffled. The lawyers are baffled. Everybody's baffled by how much activity happened in this TCPA. It just didn't go the way things normally go. That probably has something to do with this show and other YouTubers covering the case, and there being such a public sort of involvement with the case that changed the lawyers' approach to things. They started, I would say both lawyers on both sides have made movements for directly appealing to their supporters out in social media land. That's a new sort of avenue. It's not new. It's a more common avenue of lawsuits now that has to be considered. What is the social impact to my clients? Do my clients have a social media presence? How will this lawsuit and how it's conducted affect that social media presence? How can we utilize a social media presence to make decisions, to leverage things against our opponents? All of that stuff comes into play. Look at Christopher Hook on Allstate. Here he is having a conversation between it, and the judge in the hearing, the recording that we listened to, is really pissed off that everything went public, that these emails went out, and that everybody can see Christopher Hook calling these guys gay boys and stuff like that. That's what the judge is mad about. That it made a spectacle of the court. I'm sure he was really happy to have that court, to have the recording from the courtroom that he may not have authorized. But anyway, yeah. So if I've said you could, I was thinking of having you on the show, and people out there who I'm thinking of, SG Sammy, I think I may have told him a while back that I would get him on the show later. I didn't not mean that. Just been really busy. So if you've got a show idea, and I've said you might want to come on the show, Mecha Random, I think I might have talked about having her on the show at some point. If I've sent that to you, pitch me a show idea and understand that it's not personal, that I'm not entirely sure off the top of my head what we might talk about. But if you have a subject and you want to talk about it, work with me and maybe we can make something happen. No guarantees, because maybe there'll be a Lungless lawyer filing all sorts of motion practice that I don't see coming. Who knows? Anyway, so there is the senpai stuff. Draw your own conclusions. I don't really care. What do you do? What do you do? If he thinks I lied, okay, cool. Sure. I try to run transparent. If I didn't say one thing you wanted me to say, I'm sorry. Sorry. And this is genuine. There is not a hint of irony or sarcasm in this. Senpai, I'm sorry to have angered you. It wasn't intentional, but you did piss me off with your approach to getting on my show that looked a lot like John Michael Kelly's approach. It was really lame that you thought that you should definitely have some sort of spot on my show because I said 7 months ago that I might have you on. All right? There you go. Sorry, buddy. I'd say better luck next time, but I don't think there's going to be one. All right. Autofocus. Autofocus is probably Nothing ever works consistently. Yeah, it's doing it again. Hate it. Hate autofocus. Burn it to the ground. Anyway, and the amazing Lucas, enter the QB. I'm going to address your chat right now because it's on my mind. Can the amazing Lucas be a potential guest for you? Yes. I'm back from Florida, and he is up on my list of people to contact right away. So I'll be doing that over the weekend, hopefully, and getting a hold of amazing Lucas, because it's been a long time coming since HawaiiCon, where we first kind of were introduced, and not in person, but a nice connection made by Mikkel, who hooked me up to amazing Lucas. And I'd love to have Mikkel on a show also, because I really like that guy. He's a legit good dude. So Mikkel Casanova, if you guys are not familiar, you should maybe check him out. He's a good guy. But yeah, amazing Lucas are on there. I've got a buddy of mine in real life who's a cybersecurity expert, professional, and I want to have him on the show. I'm not sure exactly how we're going to refer to him, and I'd like to talk to him about cybersecurity, life, and other stuff, but that's not the Vic stuff either. And, you know, my brain's tangenting through all of these guests that I would like to talk to. We're going to do another Second Amendment stream at some point in the future, hopefully with Kendra again, and also some other people who can maybe lend some insight on what's going on in Virginia and stuff like that. And I've got another lawyer who has reached out, who's starting up a YouTube channel, and we're going to probably, he's actually got a YouTube channel, but he's going to start up a law-focused one as well. And so we're going to collaborate on something. I'll announce all this as we solidify plans. But yes, guests. I would love to talk to some more people. I love meeting people. Also, on the 6th, which is Monday, I'm going to be on, what's it called? I want to make sure I get the name of the podcast correctly. The WTF Nation Radio. I'll be on WTF Nation Radio. I don't know if that's a live thing. I think it's a live thing. I don't know if you guys are familiar with their show, but I will be a guest on their show on Monday. It's at 9 p.m. Central Time. So I'll post some promotional stuff on where to find that show soon. All right. Next thing's next. Let's read these chats. There's some chats here. Wes Nile-chan says, it makes my proboscis salivate at how much Lemoyne is in the doghouse with his firm after mucking up the fees hearing. Now is my time to strike and take the sliver of lung capacity he got away with last time. Horrifying, Wes Nile-chan. Horrifying. Willful Ignorance says, Happy New Year's, Nick. Let's have fun with this. Happy New Year's to you. Let's definitely have fun with this. Oh, and if you didn't see it, I suspect many of you have, but if you didn't see it, I did a very short 15-minute recap video on the Vic case in 2019, earlier today. Go check it out. Also, obligatory like, share, subscribe. I have to say that more because I'm bad at saying it, and I'm supposed to say it more. But like, share, subscribe. Also, the plans for the deposition videos are commencing. So, and there will be a Meyer versus Wade recap video coming up in... I'm probably going to wait till after Tuesday just to see if anything happens. There's a Meyer versus Wade has a scheduling conference on Tuesday, and I'm wondering if we're going to get that jurisdictional ruling sometime before or around then, or if we're going to find anything out from that scheduling conference that might help with an update video before I do it. But we'll probably see a Meyer versus Wade update video similar to the Vic one next week. So there you go. And I'm also hoping to put together something for the 1-year anniversary of the Vic drama, which is in 13 days. So we'll see. We'll see. All right. Next, we've got James Spoon says, Senpai noticed you too much. Also, keep up the awesome work, Nick. Hey, thanks, buddy. RJK says, to the guys from Heroes stream that said I should be here, I'm here. Nick, I was watching Heroes with 2 judges and a DA from Texas that have followed this case since it began, and they agree this case is now a money grab. Vic equals thumbs up. Wow, that's interesting. Very, very curious. RJ, completely up to you, but if any of those judges or the DA would be interested in talking to me off record about the case, please pass my email along to them. I'd be really interested to get more perspectives from people outside of the social media taint. And I mean the physical taint, you know what I'm talking about. Outside of the social media taint that is Twitter, and specifically law Twitter, because they are not a completely accurate representation of a unified opinion on the case. There's no such thing as unified opinions on the case. Oh, and also a brief shout out to Jay Woolman. Jay, the president doesn't need Congress's permission to act as commander-in-chief. I don't know how you missed that in con law. And as proof, I don't know if you heard this, but the president had the army kill a guy, and he didn't even tell Congress about it, except for Lindsey Graham. He told him. So I guess they'll just add that to their upcoming successful impeachment hearings, and all will be fixed, right, at that point. But I'll wait for your Supreme Court case citations on the president having a constitutional requirement to not act as commander-in-chief. I mean, we'll ignore the authorized use of military force and the authorized use of military power in Iraq and all of that stuff that exists already. We can actually, even without those, the president can make a national security decision. And I know you might think that the joint House and Senate resolution on the use of military power from 1973 or whatever, that somehow binds the president. But every single president who has done a military action and complied with that act says that they act in accordance with the act. They don't actually act subservient to it, because there's a legitimate separation of powers question here. And I would be very surprised to see the Supreme Court say that Congress has that Congress can somehow shut down the act of the commander-in-chief when he sees an interest in national security to be pursued through military action that is swift. Congress has the power to declare war, and they have the power of the purse over the military. That's their check on the president's ability as commander-in-chief. This is pretty basic con law, and the fact that you don't understand that's a little bit disturbing. But you do you, pal. You don't have to listen to me on it. You can find lots of constitutional law experts who will tell you the exact opposite of your weird position. So there you go. Next, Slayer Vane says, Happy New Year, Nick. Here's a donation, as I normally can't watch your streams as I'm asleep due to work. Keep up the good work. Oh, thank you. Thank you. I appreciate it. Billy Glessner says, Hi, Nick. It's officially my birthday today since it's past 12 a.m. Here, have $20 because you are awesome. Lol. Isn't it supposed to be the opposite? Aren't you supposed to get $20 on your birthday? Either way, I appreciate it, Billy. Happy birthday to you, buddy. Hope it's a magical one, and probably when you wake up or whatever. So have a good one. Spend it with people you like, doing things you like. Talon Sear says, No, sir, you're definitely right. Social media is definitely a taint. It is a cancerous growth and needs to be occasionally trimmed to keep the cheese in check. Okay. Well, I think we've stalled enough. Let's get into the transcript. Excuse me. Be it known that at 25 minutes into the stream, roughly, we are at the transcript. So here we go. Oh, here's the document. So this is all just the preliminary stuff. This happened on 21st day of November 2019 in front of Judge Chupp, blah, blah, blah. We've got appearing for plaintiffs An Lee Sue and of Martinez Sue and Mr. Ty Beard. I believe also Mr. Martinez appears for the plaintiff and does much of the questioning. So that's interesting. Appearing for defendant Funimation is John Volney. Appearing for Monica Rial and Ron Toye is Mr. J. Sean Lemoyne. And appearing for defendant Jamie Markey is Samuel Harris Sam Johnson. Samuel Sam Johnson. It's weird. Okay, so here we go. Here's the table of contents. This is the exhibit pages where they're offered and admitted, all of that stuff. So fun times. And here we are. All right, I'm going to do one voice in this, and that's Lemoyne's, just because I think Lemoyne is a special star in this hearing. Woo! And like I said, we're going to get as far as we can tonight, but I don't think we're going to make it through 190 pages. If I had to guess, that's just a lot. It's just a lot. No, we're not going to do the Martinez voice. The court says, all right, what do we need to do first? Judge, we're ready to call our first witness. Okay. Your Honor, we have filed a motion for continuance to have some additional time. I don't know if the court has had had an opportunity to review that. I had an opportunity to read it, but you didn't set it. Yes, Your Honor. Additionally, Your Honor, we did file this morning a motion to strike their exhibits for various reasons. I saw that. Okay. Let's have the hearing, and if for some reason we feel like we need more time, we'll get more time. Okay. Notice another one where he doesn't rule on the motion to strike at the hearing. This is how Chupp, getting a feel for how Chupp runs his court, right? This is how he was. You'll notice he overrules a lot of objections. Now, I did check. He does sustain some objections in this one as well. So that was kind of interesting to see him actually sustain some of these objections rather than just overrule them, but then tell people to move on and stuff. Let's see. You can call a witness. Your Honor, Jeff Helberg here on behalf of, I'm partners with Mr. Lemoyne and on behalf of the defendants Rial and Toye. At this point, we would offer in evidence 3 exhibits if I may approach. I have copies. Okay. Your Honor, I'm referring specifically to exhibits 3, 4, and 5 in that binder. The ones you're handing me, are these going to be the ones that the court reporter will keep, or do you have a copy for the court reporter? You don't have to. I have an extra copy. We have them on a thumb drive. Good assistant coaching from Lemoyne. So Helberg said, okay, I'll give this to Tina, whatever we admit. Well, thanks. That's nice. Good job. Thanks, Tina. Mr. Helberg says, okay, court, that's fine. I don't need it. Your Honor, we would move to admit 3, 4, and 5. They are business records affidavits that were provided to plaintiff's counsel more than 14 days before this hearing. We move to admit. Martinez says he said 3, 4, and 5. 3 is an affidavit. They're all affidavits, Your Honor. Okay, but you're saying the affidavit is a business record? It contains a business records affidavit. Now, business records affidavits are affidavits that are also business records, but they have a specific set of requirements, form requirements for them to be a business records affidavit. Talking about this a little bit during the lead up to the TCPA because there are form requirements for them, and if they're not met, they might get struck. So, with attachments there too, with respect to the billing records that are going to be the subject of Mr. Lemoyne's testimony momentarily. Okay, so they're offering 3, 4, and 5. Yes, Your Honor, if I can have just a moment to confirm. Your Honor, these were also attached to the motion, so they've had them for quite some time. Your Honor, if I may, the issue we have with these affidavits is that under the business records exception, one of the requirements is that the affidavits proving up the documents state that they were kept in the regular course of business. That is not included in these affidavits, Your Honor. Court says it was the regular course of business of Wick Phillips or an employee or representative of them with knowledge of the acts, events, conditions to make records or transmit information. That part? Yes, that part, Your Honor, as relates to what they did, but not the attachments thereto of those exhibits. And let me make sure, I may have missed it, Your Honor. Look at 7 on the first one. You're correct, Your Honor. My apologies. I'll withdraw the objection on that part. We have no objection to these. Okay, so they made sure the form requirement was on the records affidavit. It was. There you go. The court says, okay, exhibits 3, 4, and 5 are admitted. Helberg, thank you, Your Honor. At this point, we will call Mr. Sean Lemoyne to the stand. Court says, there's a ramp. Watch your step. And Lemoyne is sworn in. I hate coughing. All right. Direct examination by Mr. Helberg. So this is where Mr. Helberg is allowed to ask questions to J. Sean Lemoyne. Now, there are different rules for direct exam and cross exam. Won't go too far into it, but in direct exam, that's where you can't do things like leading the witness. And on cross exam, you specifically can do things like leading the witness. So a direct exam is going to have more open-ended questions. Tell me about this. What did you do here? Why? When? Tell me about doing this. Cross exam is going to have more questions like, isn't it true that you admit to this? Didn't you do this thing? You know, that sort of style of questioning. It's a lot more close-ended and it's more directed typically to get the answers that you want. So Helberg, of course, is Lemoyne's partner. So they're going to be, you know, this is their buddy system. Mr. Lemoyne, would you please introduce yourself to the court? Oh, sorry, that was rude. My name is Sean Lemoyne. And sir, what is your purpose here today? Isn't that the question for all of us? I'm here to testify on reasonable and necessary attorney's fees, along with expenses and costs as allowed under the Texas Citizens Participation Act. Mr. Lemoyne, where did you go to law school? Vermont Law School. I graduated in 2000 and became licensed in the state of Texas in November of 2000. Where have you practiced since you received your Texas bar card? Throughout the state, predominantly in the DFW Metroplex, though. What type of practice do you have? I'm a business trial lawyer, so commercial litigation. What firm are you currently with? Wick Phillips. I've been there since we opened the doors in 2004. Have you ever testified before on the issue of reasonable and necessary attorney's fees? I have. On approximately how many occasions? Live in testimony, probably 2 or 3, either before a bench trial or jury, and by affidavit, I would say easily 60 times. Are you familiar with the Texas Citizens Participation Act? Yes. How are you familiar with what we will call the TCPA? Wick Phillips first started litigating under the TCPA in 2013, and I'm probably the lead attorney within the firm that advises on that particular statute. I write a blog called www.antislappbtexas.com that kind of updates it. I wrote a version... What? Does it... Updates what? Updates Wick Phillips? I guess that's what he means. I wrote a version of the recommendations to the statute that we submitted this past legislative session through Representative Meyer and worked with the Senate side to try and get some changes. Not the ones I wanted, but some of them. I probably litigated through this type of hearing at least 12 to 15 TCPA motions. Wick Phillips has a pretty robust anti-SLAPP practice. We have, I believe, 6 or 7 opinions personally up in the 5th Circuit. I don't typically do appellate work, so I advise on the appellate issues, revise the briefs, and then talk to the people that are going to argue to the Court of Appeals about issues. Woo! Have you presented CLE's continuing legal education presentations on the TCPA? Yes. Are you... Oh, God. So imagine unironically, you're a helpless Texas lawyer, and you're required to go to a certain amount of continuing legal education every year or whatever to keep in good standing for your license, right? There's a requirement that's part of your ethical requirement is to make sure you stay informed, and you get a broad discretion on what topics to keep. You think, you're like, oh man, this TCPA is kind of an interesting thing. And I saw some weirdo on YouTube talking about it. Maybe I should go bone up on it and make sure I have the best law Twitter arguments out there. Let's see. I'm going to go sign up for it. Oh, it says this guy's been litigating the TCPA for the past 7 years and is some sort of expert. And then you go in and you sit down and you're like, all right, sit down and listen to this expert. He comes out and he's like, hi, my name is Jay Sean Lemoyne, and I'm going to talk to you today about the Texas Citizens Participation Act, or TCPA for short. Like, can you imagine what that would, you would, oh my gosh, you would be begging for an inert hand grenade to choke yourself to death with. Just, whew. All right. Super Sacky VA says, Nick, in honor of the most lemony lemon, Leningrad from Adventure Time, can we get a big, loud, big, long, unacceptable in the voice of the Lemon Führer himself? Other than that, keep being awesome and being you. Unacceptable! I hope that worked. Oh boy. Okay. Are you familiar with rates in Tarrant County? Yes. Tell the court how you are familiar with rates in Tarrant County. Like, these are always weird when they forget that they didn't ask a question, so they have to do the vocal fry at the end. Well, first of all, Wick Phillips has a Fort Worth office, and it's had a Fort Worth office, I think, since 2006 when Brant Martin opened that up. And then David Drez came over from Hines and Boone. I've worked with the Hines and Boone attorneys, specifically Steve Pezanowski, as a senior. He may be still a managing partner at Hines and Boone's in Fort Worth. In preparation, look, oh my God. Look at how much he talks. In preparation for this particular testimony, in addition to talking to Mr. Drez about Fort Worth, Hines and Boone rates, Wick Phillip rates, which I can access, I also talked to a senior level partner at Jackson Walker to determine what their Fort Worth rates are. And then I got additional data points from Kelly Hart and Allman. Specifically, I talked to Jeff Whitfield. Listen to this, his list of torture victims, who's a younger partner over there. He was on the case called Henry Lipsky that went all the way to the Texas Supreme Court on anti-SLAPP. I talked to Jamie Welton, who recently had an attorney's fees award in Fort Worth in February of 2019. He's at Barnes and Thornburg. We are lucky enough to have several Fort Worth associates that have come from good firms like Whitaker and Chalk. And I also want to mention Harris, Finley, and Bogle. Harris, Finley, and Bogle was the firm that did the Range Resources case that went up to the Fort Worth Court of Appeals. I think that's it, and so I was able to get a range of the fees, you know, kind of starting at Harris, Bogle all the way up to Jackson Walker, which is and Hayes and Boone's, their top end of fees. Woo! In determining a particular timekeeper's rate and what would be a reasonable rate, what are some of the factors that should be considered in making that determination? And I'm just talking about the rate at this point. Oh, God. It's like asking... It's like asking an autism for the backstory on Sonic. So the Supreme Court issued an opinion called Rormoos Ventures. I think it's ROHMOOS a few months ago, and that kind of changed the game with regard to how Texas attorneys' fees are determined. Prior to the time when we that time when we all relied on Arthur Anderson, its progeny, Rormuz says there are basically 9 factors that come from the Texas disciplinary rules, and you consider all 9 of those factors with the exception of the undesirability of the particular text you're looking at, skill set of the attorneys, novelty and complexity of the issue, whether or not you took the case on a contingency or whether or not you deviated from your standard hourly rates. But in terms of coming to a reasonable rate, certainly a 25-year lawyer could command a higher rate than a first-year lawyer, obviously. And if someone had board certification or not, that would go into factoring whether or not the rate was reasonable. That and if they had expertise in a particular topic like the Texas anti-slap. Well, who's verifying the expertise there, buddy? At Zuma99 says, hey, Nick, hope you had a good Christmas and New Year's. I did. Hoping you call Lemoyne a swamp beast at some point like you did in a previous stream, because that was really funny. It is pretty funny. Keep up the great work, man. You're awesome. Hey, thanks, buddy. You're awesome, too. West Nile Chan says, wait, so he doesn't handle the appeals, but this is his first win under the TCPA and he's not going to defend it on appeals? I don't know if this is his first win under the TCPA. I'm not sure about that. I've never actually looked up his record, which there isn't like a record, but I haven't gone through all of the cases that he has on appeal out there to see if he won or not. Not sure if he got canned for messing up the fees hearing or if he just lost interest in appeals. Well, we'll see. We'll see. And for example, experience in the topical area can make a difference in the rate. Yes. With respect to the timekeepers that have billed time that forms the basis of your opinion today, can you tell the court the name of the timekeeper, the rate, and why you believe, if you do, that the rate for the timekeeper is reasonable? Yes, I can do that. Would you like me to? Yes, I would like for you to. Because he technically didn't ask him to. He just asked if he could. So he even answered pedantically to his own counsel. Okay, Jeff Helberg, which is you. You are a 23-year lawyer. Your rate is $650. His power level is 650. That is at the upper end. That's more consistent with a Jackson Walker rate or a Haynes Boone rate, but it's a little higher than you would get at Kelly Hart, and I'm talking Fort Worth specific. Your rate is justified, in my opinion, because you are kind of one of the foremost people in terms of arguing Texas anti-slap cases at the Court of Appeals. You're also double board certified. That's like double secret probation, which is part of the reason why you've been here at some of the bigger hearings, because you protect me on my back end. Wait, on the back end. Oops. On the back end, with your both being both a trial lawyer and a board certified appellate lawyer. So I don't need to bring any separate lawyer when you and I try cases. We're a great duo, buddy. We're a team. You get to protect all the appellate issues and I just argue with people. Oh, God, poor people. Can you imagine being people? So that is why your rate is $650, and even though there's only a 4-year difference between you and I, that's why I'm at $515 and that's why there's that much of a jump. You're just so cool. With regard to Jeff Mills, he's a 9-year. His rate is $470. Ethan Minshall is an 8-year, and his rate is $435. Zach Farrar is a 5th year, and his rate is $395. Casey Eric, who is now with Cowles and Thompson, formerly Kessler Collins, his rate is $275. Poor Casey. Casey's like a 19-year, isn't he? Or 11 or something? Jeez, he's getting wrecked. Andrea Perez was an associate at Kessler Collins. She has now moved to Carrington and Coleman, so her rate is between $275 and $300. They should mandate law firms not have the names of the lawyers in them. Now, with respect to, you mentioned the Rormuz case. Sorry. I just was still going on as Lemoyne. Now, with respect to, you mentioned the Rormuz case. And under the Lodestar method, how do you calculate a reasonable fee now under Rormuz? Okay, so there's a couple of different ways you can do it. Some people take a blended rate of all the timekeepers and multiply that to get a total number. So it's reasonable hours times reasonable rates. I do look at it differently in that I am timekeeper specific. So for Lodestar, once I determine this is the reasonable hourly rate, we'll take my rate, $5.15 an hour. And then how many hours should I have spent on a particular case or a particular activity? And then you multiply that out and you do that for each timekeeper. Now, notice what he says here. How many hours should I have spent? Not how many hours did I spend? Remember, this is reasonable attorney's fees, but it's not all attorney's fees. You can't just do 30 hours of research and say, well, I did 30 hours of research. I'm entitled to 30 hours of fees. It doesn't work that way. How much should you have spent? It's part of the ethics. Wes Nilechan says, if Lemoyne wasn't so into the anti-slap, he might have been able to swap me away before I took away his pulmonary independence. Oh, God. It's like Bill Paxton in Vertical Limit. We're going to get pulmonary edema. Got to eat these pins. Sorry. And then you add it up, and then you, under Rormuz, you have to take an extra step, and the extra step is called billing discretion or billing judgment. Prior to Rormuz, that was not a requirement. Under Texas law, you see it in the federal courts, but you don't see it in Texas. The reason is when you're trying to shift attorney's fees, so what I and my clients agree to is not what I can shift off to a party under a fee shipping provision. I don't know if you followed that paragraph. I'm going to reread it. It doesn't flow very well. It's not just, I'm not doing the Slowpoke Rodriguez voice for Martinez. I'll die. This will take forever. It's not just Lemoyne's lacking lungs that caused him to be unable to communicate very well. Like, this sentence structure is, under Texas law, you see it in the federal courts, but you don't see it in Texas, period. The reason is when you're trying to shift attorney's fees. So what I and my clients agreed to is not what I can shift off to a party under fee shipping provision. At least he's honest there. So the Texas Supreme Court came out with Rormuz and said, if you're going to push this money off onto the loser in the lawsuit, one of the things you have to do is go through and do a billing judgment or billing discretion analysis to try and eliminate excessive time, duplicative time, that type of thing. Or time that wasn't properly spent on recoverable issues. Time that wasn't properly spent on recoverable issues will become a factor in the decision here. Sometimes you have a segregation issue. Oh, look, J. Sean Lemoyne is bringing back segregation. What a shame. We have had that in this particular case. Okay, in your 19 years of practicing law, are you familiar with tasks that are necessary to perform to represent a client in litigation and in particular a TCPA motion? That's a double question, a two-part question. And the answer is yes to both. Oh, God. Unlikable sod. The grass. Okay. Yes, I take cases from soup to nuts. All the way through trial. Gonna coup. Sorry. I take cases from soup to nuts. All right. All the way through trial, and then I advise on appellate issues at the end. And with regard to TCPA, you never have a trial, meaning there's never a jury in the box. Can't say you never have a trial. Otherwise, you're Your time limit argument doesn't hold water. What we're doing today is about as far as you ever have to take it, which is an attorney's fees and sanction determination. That can be done a number of ways. Yeah, no one would want to put you in front of a jury. That would be a disaster. If you formed an opinion as to what is a reasonable fee, as to what is reasonable fee would be in connection with the motion to dismiss that is the subject of today's exercise? I have. And in forming that opinion, did you base it on, in part or in whole, on exhibits? What have been admitted in exhibits 3, 4, and 5? Yes, and for the record, I have exhibits 3, 4, and 5 in front of me, which are the affidavits of myself, Ms. Perez, and Mr. Eric, who I worked with on this case. Oh, okay. Quantum Videos says, sorry if I can't donate more often. Nick, don't apologize for not donating to me. Oh my goodness, please. I'm just showing my appreciation for entertaining me every night and always being positive, man. I hope you don't mind me saying, God bless you, Nick, and your family. Thanks. I would never, ever mind saying that. And thank you very much. I appreciate it. But please never apologize for not donating. That makes me feel terrible. You're under no obligation to that, and I would never even ask. If I was ever asking you to donate to something, it'd be to something other than me. All right. Like the GoFundMe. And I'll be bringing up the GoFundMe when they mention it. Don't worry. Okay. Before we get to the number, can you describe for the court how you arrived at that number with respect to the reasonable fee? So the rates, this is a lie. This next paragraph is a lie, and I'll tell you exactly how he did it after we read the lie. Let's read the lie. So the rates charged on the invoices being based on my analysis of market rates and rates both in Dallas County and the Fort Worth level, these would be reasonable rates for all of the timekeepers. I didn't try to ask for an enhancement, although I would certainly argue that Mr. Eric and Ms. Perez are worthy of an enhancement and they would be entitled to it. Lie. He looked at the GoFundMe amount, tweeted about it every freaking day, and that's how he decided the fees. That's it. Everything else is backwork on getting to something close to that GoFundMe amount. Make no mistake. And then I've looked at the billing records, and based on the billing records, I did certain deductions to satisfy the billing discretion analysis. He can't say analysis. It's really weird. Which is Exhibit B to Exhibit 3 to my affidavit. Exhibit B is my billing discretion determinations. So if you look at Exhibit 3, you'll notice that there's highlights on certain time entries. And those are time entries that I went through based on 19 years of litigation and 6 years of TCPA work and said these need to be reduced for one reason or another. I did that calculation on an Excel spreadsheet, tracked it, identified it by timekeeper, and so if you look at the Exhibit B to my affidavit, you can see the exact reductions that I have made to meet the Roar Moose billing discretion analysis. Dang it. After that, it's just a function of math as to our timesheets with regard to, and then I included Mr. Eric's and Ms. Perez's fees. Mr. Eriks at Kessler Collins already did his own business discretion analysis as he went along. You could see that it in the form of no charge. So there's a lot of things that he did that were no charge to his client. And so those function the same way because he could have passed them along to his client, but he didn't. And so we're not passing them along to the non-moving. Okay, let me clarify something. In Exhibits 3, 4, and 5, it identifies a specific timekeeper with a specific rate, does it not? I'm actually not going to ruin my voice if I keep this up. My voice feels better after doing Lemoyne's voice. Shocking. I know. But it's true. That's the weird thing. Wait a minute. We have new merch? We have new merch right now? Hold up. There's new merch available. I'm going to take a look at it. Come on. Oh, it's the Lost Planning logo on a shirt. That's cool. You can go check it out. It's in the description. I'm not going to bring it up on stream. If it was a joke relevant to the case, I was going to bring it up on the stream. But You can check that out on the Teespring store. You can also see other stuff, but it's in the description. Anyway, let's get back to this. Okay, let me clarify something. Oh, wait, I just read that one. It does. Do you have an opinion as to whether or not those particular rates for those times are reasonable? Yes. What is that opinion? The opinion is it is based on the discussion about Fort Worth rates, the discussion of these factors that you can consider under Rohr-Moos and the Texas disciplinary rule. Okay, and with respect to the fees that we are asking for today, that is an amount less than the cumulative total if you add up all those fees, right? That's correct. Do those records indicate all of the fees? Meaning, does it include time spent in November, for example? No. Do you have an opinion as to how much the fees should be added to that to reflect the time spent in November of 2019? I do. All right. And prior to coming here today, did you prepare a summary of the fees for your testimony? I did. All of the defendants did, and it's contained in Exhibit 7. And as to your summary or your testimony that is contained on the last 2 pages of what has been marked as Exhibit 7, that's correct. Your Honor, at this time, we would move to admit Exhibit number 7, and in particular, the last 2 pages as a summary of testimony as permitted under Rule 1006 as a summary of an expert. And Your Honor, I will acknowledge that the first couple of pages, there's been no testimony, but I anticipate testimony from the other defendants to support that part. Therefore, at a minimum, a conditional admission, but in particular, the last 2 pages. Martinez, should I do Slowpoke Rodriguez? Your Honor, he anticipated what... No, I can't. That's so rude. He anticipated what my objection would be, which is there's no foundation at all for anything but the last 2 pages in this. The court says, can we just admit it after you put the rest of the foundation? That's a good question. Ryan Mercado says, finally, Chup realized he was being played by Lemois. Lemois keeps asking the same question differently. Also, geez, Lemois is so obsessed with the GoFundMe, he spent an hour talking about it. Also, where's my cut, Nikki? Hey, the check is in the mail. Tom531Cat says, welcome to Lemoyne's fan fiction. Watch as he will mystify you with his astounding logic in the story he tells you. Be amazed as he reaches for every inch towards GFM, but to only have his dreams crushed by Nick, the mastermind. A tale of greed. You want the Slowpoke Rodriguez? Oh, we'll see. We'll see. The merch listing and description is the joke. What is the grift? I'll maybe do it in a minute. I want to get through part of this. Mr. Helberg's response to the court's question. Can't we just do it later? I'd like to ask him, well, I can't set the foundation with this witness. We've got other people. I've got it broken out. We could mark it as 7A for just those last 2 pages. Okay. Are you all right with the last 2 pages? No objection to the last 2. No objection to the last 2 pages. Okay. Exhibit 7A is admitted. Mr. Lemoyne, in your opinion, what is a reasonable fee? You're familiar with how the PJC breaks down fees, correct? Yes, sir. So with respect to the fees through the trial of the case, what is your opinion as to a reasonable fee for the defendants we represent? If you look on page 2 of Exhibit 7A under the totals column, through October 31st, it is $271,923.80. And with respect to, and that covers the fees up through October 31st? That's what I said, cunt. That was rude. That's a partner. That's a partner. And with respect to the November fees, tell the court how you arrived at the $11,250. When I talked earlier about the rates, that's what I did. I made some assumptions about the amount of time it would take in November to file the attorney's fees brief, respond to any particular issues that came up with regard to what the plaintiff might do, prepare for this hearing, and get up to speed. So I made an assumption of $4.50 an hour times 30 hours, which is based on kind of a split between myself and Mr. Minshall. And in your opinion, is $4.50 a reasonable rate for a blended rate? Yes, he has applied all the same discussion factors that we had earlier. And that is a more than a reasonable rate. And in your opinion, is 30 hours a reasonable rate, reasonable amount of time for the services for November? It is. It's probably objection. No, objection. There has been no foundation laid whatsoever as to the details of how he reached that 30 hours. All he said was how much time I thought it would take to work on the motion. Overruled. I've noticed that Chup is not a fan of objections, in my opinion. He overrules quite a few of them. That is, Lemoyne just above says he guessed. Now, Chup doesn't have to sustain the objection. He can overrule it and ignore what they're going to say and just take out those 30 hours, right? I'm not giving him that 11 grand. I don't care. But he overrules a lot and then just moves on. I don't think he's the biggest fan of interrupting the flow. He seems to be a guy who wants to hear the arguments. And that makes for some complications with objections. If you'll remember at the actual TCPA hearing, Ty had several objections in a row, and the judge told him, stop standing up. Stop objecting is what he was saying. Stop objecting to these people. Stop objecting. And it's like, that's his job. He's required to keep objecting when it's objectionable, and you need to preserve the objection. But the judge tells you to stop objecting. I don't think he's a big fan of objections in general. But he does, like I said, I did go through, he does sustain some of them in here, which I found interesting. He has not sustained very many throughout the case. How did you arrive at the 30 hours? Well, I've been through these before. And so I made some assumptions as to the complexity of the attorney's fees that we were going to have to submit the sanctions component of it, how much time I thought it would take for briefing, an estimate that the other side would file a brief, and we would have to review that, the amount of time it would take you and I to prepare for this and to follow up all the evidence and particulars. So through the trial of the case, what is the number that you are presenting to this court as a reasonable fee through the trial of the case? On the second, on page 2 of 7A, where it says final trial fees, the amount is $282,953.80, and there's a reduction noted by footnote. Apparently, we all allowed a fee for, not this case, it was Mr. Eric. There was a fee in there for another case that he was dealing with that somehow got categorized, and we all missed it. So I backed that out. It was $220. Yeah. Somehow. Now, Mr. Lemoyne, you've handled a number of prior TCPA motions, right? Correct. Hey, what's up, Ty? How does this fee compare to other motions in the TCPA context in terms of amounts? It's bigger. I like it big. Can you explain to the court why? Sure. This case had a layer of complexity to it that you don't typically see in a defamation case. The first issue is that it primarily deals with Twibble. Did this which is the people's combination of Twitter and libel. There's no real Texas case law on Twibble, so you have to research outside of the state of Texas for that further. You don't really. Because libel is just written defamation, and Twitter is a written published medium. This isn't that complex. Oh, gosh. It was compounded by the fact that there was something done in this case that I've never seen done before. When you proceed under a liable case, you have to include the entire context of the alleged defamatory statement because it's a publication rule, and the courts have uniformly said you have to have a context to it. Well, here we are dealing with statements completely out of context with no surrounding what the person was responding to, who they were even talking about. At the depositions, there was 200 pages of Twitter posts put into evidence or put into the deposition where you have the Twitter post that blanks all around it. It's literally impossible to provide all of the context to Twitter posts. Like, imagine all of the different context going into it. If it's, but here's the interesting thing. These are trial issues. These are not TCPA issues. And they should know that, but. Well, that's not how Twitter works. The response is to something. Not all of them were responses, homie. In order to determine defamation, whether or not the statement was defamatory, you have to know what the context is. Sometimes. That is compounded by the fact that people are no longer proud of what they wrote on Twitter can make it disappear. I mean, and so we don't know and we'll never know what the context was around several hundred pages of evidence that the plaintiff tried to introduce. So that was the first issue. The second issue is the concept of whether or not a sexual predator being called that is defamatory is not something that Texas case law has addressed. Listen, guys, not defamatory to call someone a sexual predator, apparently. So the specific wording used is just, there's not a specific case that used the word sexual predator. I'm not 100% convinced of that. But secondly, it's defamatory. It is a defamatory statement. Whether or not it falls under legally actionable defamation is a question for a jury. That's a question for a jury. Anyway. The only case to address it that I have been able to find is the Mogged, Mogged versus Lindamood case. It's up on appeal it's currently in the Texas or the El Paso Court of Appeals, but the case actually originates out of Fort Worth. That's the only one that talks about whether or not being called a sexual predator, is defamatory. So we had that particular issue. What did it say? I wonder what they, that's interesting. Let's see here. Let's see. Given the content of the deposition, we are unable to say that Lindamood established a prima facie case that Fletcher's attitude towards the truth was the ilka. In other words, he did not present a clear. Oh my gosh. Okay, I don't have time to suss this out. Really curious what they decided. Let's see. They focus on the malice aspect of the argument. At the very least, it is reasonable for an ordinary person to so believe. Okay, wait, here we go. Much the same can be said with Fletcher's use of the phrase sexual predator. Lindemood himself described the term as connoting someone who forces sex on an unwilling victim. That such unwillingness may come in various forms is indisputable. The law prohibits taking sexual advantage of a female whose decision-making process or judgment is impaired by intoxicants in one such form. At the very least, it is reasonable for an ordinary person to so believe. Here, Lindemood acknowledged within the deposition excerpts distributed to Fletcher that his stepsister was indeed drunk when placing his hands on her breasts. When she removed her bra and threw it, stepsister. When she removed her bra and threw it upon a table, when she went to lie on a couch, when he left his bed to join her on that couch, and when he pulled up her shirt and began touching her thighs. Why did he have to pull her shirt up to touch her thighs? He also acknowledged under oath her telling him the morning after that what you did was wrong, that led to him accusing her of being the aggressor, as he put it. You're the one who led it up to that. Okay. This is a malice argument, though, but I think they pretty much say right in there that an ordinary person could believe that to be defamatory, because of course they could. Of course, calling someone a sexual predator is defamatory. I mean, that it's not just defamatory; it's likely per se defamatory. But I'm getting ahead of myself here. E1337 Neo says, Nick, take a pair of Sawbucks to go toward any beverage that'll help your poor vocal cords out. They're fine. You should have invited Dame Pesos on to do Martinez's voice. Last but not least, let's get hashtag Tecuppa and soup to nuts trending. Oh my goodness. Omega 000 says, coming in late, not gay because I'm bi. Happy 2020 and have some whiskey muns. Go Titans. Hey, thanks, buddy. I appreciate that. Even though the Titans did beat the Texans, which was a shame, but the Texans really didn't need to win that game, so I guess it didn't matter. So, good job, Titans. All right. Then we had just within the context of this particular argument, you had a fight over public versus private distinction, because whether or not a public person was either a public figure or a limited public figure changes radically the standard in which the court evaluates defamation. So that was a big fight, and in those contexts, there's not always a lot of case law that is on point, so you had to do that type of research. We were hit with a battery of evidentiary objections at every turn. This morning is a good example. Right before we walked in, we got hit with 7 pages of every objection you could come up with. Oh man, how dare they object to your evidence? And that was every evidentiary issue we had. We were met with that. We were met with continuances, things that really drove up the cost. There was wasn't there one continuance request from the plaintiff? The rest were from the defendants. We had to fight harder in this case than I've had to fight in most anti-SLAPP cases. Oh, man, that sucks. By the way, I don't know if you guys caught what just happened here. For all of the bleeding of law Twitter, Lemoyne is here saying that Beard, Harris, Bullock, and Hughes apparently fought harder for their client than anyone else Lemoyne has ever had to go against. I think that's actually a nice compliment to Beard Harris. Look at the work they're putting into this. They're objecting to stuff. I mentioned this before. It's one of the advantages of the GoFundMe, right? Is that there's a pool of money that can be used to do stuff where in other cases, your lawyer might say, well, doing this would cost more money. Are you sure you want to go through with that? There's this pool of money that allows them to fight harder. Think about that. Anyway, it's an interesting point. This has been the hardest fight Lemoyne has ever had to do in all of his years as a TCPA expert. Why? Why was it so tough? Your opponent was Ty Beard, the worst lawyer ever, right? Okay. The other thing that was unusual about this case is that the plaintiff was actually put up for deposition. I've never seen that before in the 15 cases that I've done in anti-SLAPP. Okay, so that's clearly outside of the scope of anti-SLAPP. Listen, this... Think about this. Think about this. This guy is talking about reasonable fees necessary to fight a TCPA case, right? And he says that never in 15 cases that he's done has he seen this in a TCPA. And it's something that the plaintiff cannot initiate, right? The plaintiffs don't get to call the plaintiff for deposition. I mean, I guess they could. That'd be really weird. But the plaintiff similarly cannot actually start the TCPA. They can't do it. The defendants have to file the TCPA. So never before in 15 cases has he seen it. So he's just going ahead and obviating all of the costs associated with that in the judge's mind. Well, then, you didn't have to do it. You've never had to do it before. Why would the cost for the deposition be included in a TCPA if it's so far out of the ordinary? And you guys requested it, and you guys didn't file the TCPA until after the deposition. Mithrin Emrys says, so exactly which court determined that Vic is indeed a predator, Jay Sean? When and where specifically was he determined to be one, Lemon Boy? We'll wait. We'll wait. All right. You never put the plaintiff up if you don't have to. Again, you noticed him for deposition. You could have filed the TCPA earlier. You didn't. You noticed him for deposition. And so that added a layer of cost, but it was really good for us because we got to shut down or flesh out the lack of support for the claims in the case. And we were able to introduce that through a fairly complex anti-SLAPP motion. Our anti-SLAPP motion in this case is the most complex anti-SLAPP motion that I've ever litigated before. There are a couple of unique issues in that regard, with regard to there's a Communications Decency Act affirmative defense that has never been ruled on in the state of Texas with regard to what is called retweet liability. It was ignored by the court. Meaning I retweet something that somebody else says, am I protected by the CDA? No, you're not. There's a liable, not automatically. No, you're not an internet service. You're not a service provider. There's a libel proof affirmative defense that you rarely see in defamation cases. It also doesn't apply in this one. Clearly, he's not libel proof. The libel did damage to him. So that's self-defeating. There's a consent affirmative defense that you rarely see in defamation cases. Also a ridiculous argument. These are things that the court doesn't mention, weren't really argued at the hearing at all. And I believe when he was making his CDA argument, Chup just said, can we talk about the motion? Like he didn't even care about these affirmative defenses. They're an absolute waste of time. We also had some really weird vicarious liability issues. In addition, we had some TCPA specific issues, including a fight over whether or not we could supplement the motion to dismiss. There's no case law on it, so we had to pick a fight with the plaintiff over that. We wanted to take discovery of Nick Rekieta, who is an integral part of the case and certainly a responsible third party if this case... Let me stop you for a second and talk about that. What? Me? How am I an integral part of this case, and how could I possibly be a responsible third party? I'm not involved in the case, homie. Oh my God. There was a response filed yesterday where they are critical of watching a whole bunch of YouTube videos as to the time. Do these bills in time reflect time watching a whole bunch of YouTube videos? No. In fact, I had to suffer through those, but I didn't bill the client. Person next to devil. Lots of research into Nick Rekieta. I'm pretty curious about that. Why not? Well, you know, only one of us had to suffer through that. And they shouldn't have to pay for it, so I did it. Why are you lying? I know Casey Eric watched some of them. So not only one of them, not only one of you, and I'm betting some other staff of yours watched it too. Perception Check says, careful about asking the Lemon Fuhrer for evidence proving Vic is a sexual predator. That'll earn you a block. The facts are totally on their side. That'll earn you a block even if you're friendly. All right, here we go. Well, to be sure, you spent a whole lot more time. You want to know why I watched it? Is that what you're asking? Witnesses aren't allowed to do this. Witnesses aren't allowed to ask the questions of themselves, but, you know, you have to object to it if you want. Martinez is just letting him go, but the reason... why? Well, no. Okay, why? The reason I did it is because it became very apparent early on in this litigation that somebody not associated with the defendants was leaking information to Nick Rekieta. How do you know they weren't associated with the defendants, Jay Sean? You still don't know all my sources, buddy. Who is allegedly an attorney out of Minnesota. He has a YouTube channel. He goes on there and says any number of terrible things about people involved in the case on our side. Only the terrible. Only the terrible ones on your side, by the way. Like, I don't think I've said anything about Hamburger, who's questioning you. He also discusses legal strategy and, Your Honor, he is getting into all sorts of facts and details that have never placed by before the court. Overruled. And so Mr. Rekieta would actually say things that we would see showing up in motions and in hearings. Yeah, there's this interesting thing where if you're an attorney, you can sometimes figure out what other attorneys are going to do. But on the same breath, you're going to say how I'm wrong about stuff. So that's interesting. Would actually say things that we would see showing up in motions and in hearings. I'll give you a good example. Right before we argued the anti-SLAPP motion to dismiss, Mr. Rekieta misunderstood a holding from one of the Texas Supreme Court cases, went on his YouTube channel, and he blabbered on about how this was a game changer, which I believe was wrong. He was talking about footnote 7 in the KPMT case, which is dead wrong about what it meant, so we were able to brief it. Why'd you brief off of what I said rather than what off the plaintiff was saying? I believe the plaintiffs had a whiteboard that was sitting up there laid against the wall, and they were going to show that particular KPMT footnote. Objection, Your Honor, that calls for speculation. Why do I care about this YouTube stuff? Excellent question from the court. Oh my goodness. Because it drove the cost up in this case. It drove up your cost in the case? Yes. Your Honor, if I may, he testified a moment ago that he didn't bill for any of those things, so how does it drive up cost if he didn't bill it? I didn't bill to watch them. I did bill to deal with the legal aspects that they were disclosing. Who's they? Me? I'm not the lawyer in the case and wasn't disclosing legal aspects. Why don't you tell me what you billed for? Isn't that what I need to assess the attorney's fees on, what you actually billed for? Yes, sir, we have done that. Then why are you doing this? Your Honor, the only point is that he spent a lot more... Oh, wait. Your Honor, the only point is that he spent a lot more time than what we actually billed for to show the reasonableness of the rates that we actually billed for. And that is the point of the testimony. I'm happy to move on. Okay. Okay. If I can get a ruling, Your Honor, on the objection. Well, it's overruled. He's moving on. See, this is how Chup approaches a lot of objections. But this argument doesn't make sense, right? The reasonableness of what he billed for is that he didn't bill for things, so the things he did bill for are automatically reasonable. Nope. That's if P, then Q, P, so F. No, it's not how the logic works out. Mr. Lemoyne, are you familiar with the appellate process? Yes, for all the reasons I outlined above, and I've worked with you for a decade. Okay, with respect to an appeal to the Intermediate Court of Appeals, do you have an opinion as to what a reasonable fee would be for our defendants in defending an appeal to the Fort Worth Court of Appeals? If I could speed this up a little bit, if you look at 7A, page 2, there's a listing of the appellate fees. There's 4 levels of potential conditional appellate fees that you are entitled to under the TCPA. And using the same analysis that I did with regard to the rates under Rormu's, what you typically bill, how it is staffed with associates, what you and I thought the hourly, the amount of time was, I came up with those rates. And for an appeal to the Fort Worth Court of Appeals or whatever Court of Appeals it's $55,000, which is $500 an hour times 110 hours. And in your opinion, the $500 an hour is a reasonable blended rate? Yes. And the 110 hours is a reasonable amount of time? That's correct. Okay, if you could do that for all. So with regard to each of the other phases, petition for review, and if the Supreme Court, the other side files a petition for review, and the court wants to hear your side, they tell you to brief, and for that is one phase. Then if the court wants to hear the argument, then you have a merit phase. Then if the court still wants to hear you argue, then you have an oral argument phase. So reasonable and necessary fees applying the same standards to get to the lodestar reasonable rate. Then you do an hour calculation for petition review. It's $500 an hour times 25 hours for merits briefing, $500 an hour times 45 hours for oral, and $500 an hour times 30 hours. So if we were successful at each stage, assuming there's an appeal, then those are the numbers and the math is done on page 2 of 7A. Woo! Woo! The sad thing is, it took him longer to say this in court than it's taking me. I'm actually speeding up his voice. In informing your opinion as to the number of hours reflected on 7A, did you confer with our partner, David Drez, with respect to that? Yes, he's been to the Texas Supreme Court for oral argument on a couple of cases recently. So that helps us with determining the amount of time you would need for that particular issue, because it's a big deal if you get to do that. Okay, with respect to costs and expenses, have you formed an opinion as to what reasonable costs and expenses are in this case? Yes, so the expenses are all attached to exhibits 3, 4, and 5. Then we have another exhibit 6 that we need to introduce. But once that is introduced and you can look at them, they're all broken out, and we tried to break them out somewhat on 7A, so it's reasonable and necessary costs incurred with regard to this particular case. So we had deposition fees and costs, which I'm familiar with because I've been doing this for 19 years. We had Westlaw research costs, we had parking costs, we had a mediation cost, we had inhaler costs, we had a CPAP cost. We had to get witness affidavits around the country, the affidavits for the motion to dismiss. So they actually didn't need those. They actually didn't need those at all. But, you know, that being said, and he knows they didn't need them. They didn't need them because you don't get to controvert the evidence in a TCPA. But whatever. It's not their burden. And so, in my opinion, those are reasonable and necessary. And the total amount is $15,526.96. Page 278. The calculation is done. The supporting documents are contained in Exhibits 3, 4, and 5. And now you're going to get me to introduce Exhibit 6. That is wholly improper. This should not be done. I mean, there's nothing you can really undo, because even if you object, he'll just then lay the foundation for Exhibit 6 and offer it into evidence. But this is not how it goes. Mr. Lemoyne, what is Exhibit 6? Exhibit 6 consluts of 2 invoices that came in after we submitted the briefing on November 4th. One of them. Both of them we just didn't see until somebody brought them up to us later. The first part of Exhibit 6 is the deposition transcript cost for CSI. Objection, Your Honor. He hasn't offered the exhibit to go into detail as to what it is. Well, he's reading from it. He can tell me what it is. I don't even know what's your objection. It's hearsay. Okay, overruled. I mean, objection foundation. He objected to the foundation, but, you know, here we go. Like I said, Chup, not a big fan of objections. This isn't even admitted before the court yet. Exhibit 6 isn't even before the court yet. Helberg does it after the objection. Okay. JXDBX says, welcome back. Here is overtime super chat for last weekend stream you did. I still owe you for the weekend before that. Also, I was told it's not G-rape if their pupils turn in hearts. Ask any lawyer. Is that true? No. Well, I mean, it is in Nebraska, but not anywhere else. Dustin Fritz Farr says, hey, Nick, I wasn't planning on sending a super chat tonight, but something came up. You should think about covering the SCP Foundation copyright shenanigans that's going on. I'm sure they'll need the signal boost. I've seen a couple things about it. I'll look into it. Siren Jag says, my God, I listened all the way home from work. How much longer is the Wick Phillips daisy chain going to last? A while. We're on page 36. I'm going to propose to Courtney Love if this lasts much longer. No, don't do it. It's dangerous. Don't do it. So, a formal move to admit. I'm gonna make sure I'm not mistaken. That's 6. Move to admit Exhibit 6. I'll object to hearsay, Your Honor. There is no business records affidavit for it, and it was not included as part of the business records affidavit in their original pleadings. We would object to it being admissible. Your Honor, it is a document that is relied upon by this expert to form opinions as to what a reasonable fee is. Therefore, an expert is going to rely upon hearsay evidence. Does that make it admissible that they relied on it? He can testify about it. That doesn't mean it necessarily comes in, but he can certainly testify to the contents of the document. I can also lay a business record predicate. I object. Yeah. The witness is not allowed to make legal arguments to the court. Just so we're clear. I object, Your Honor, to the witness. All right. He could say how much the deposition cost. So sustained. Oh, you sustained the objection. There you go. So they don't get to admit affidavit or Exhibit 6. Lemoyne can testify to it, but he can't admit it. Mr. Lemoyne, what were some of the deposition costs that were incurred with respect to this matter? So with regard to the deposition of Mr. Mignogna, Courtroom Sciences billed us $2,228.10. And is that number included in the $15,000 or is it in addition to? It's included. It's included? Yes. Yes. Okay. I passed the witness. Ask me about the second page. Yeah, you don't get to do that. Then Chup steps in. That's really weird. You don't get to tell him what to ask for. That's not how this works. No, it's not. No, it's not. Sorry, Judge. Are there other... You can sit. You can sit. All right. And then Lemoyne refused to fillet him that night. You didn't ask me about page 2. I'll still do it. If you're curious what I'm using to lubricate my vocal cords, it is Knob Creek Small Batch, 100 proof, Kentucky Bourbon Whiskey. All right, now we're at cross-exam. As I mentioned before, cross-exam is different. You get to do leading questions. In fact, that's typically the strategy: is you lead the client or you lead the witness to say what you need them to say to make your story. Because if you just ask them what or why, they're going to blather on about why they're correct and their side's correct and you're wrong. So the courts have this built-in thing where you get to make them answer yes or no questions where you're like, yeah, aren't you a horrific rapist? Stuff like that. I can't do the Slowpoke Rodriguez voice for all of this. That'll take way too long. I'm not going to. Sorry, I'm just not. Mr. Lemoyne, I have some questions for you. You testified, plus, that's mean to Mr. Martinez. You testified earlier that you researched into the range of hourly fees for different attorneys within the Tarrant County area. Yes, sir. What was the range for associates that you found exactly? What was the bottom to the top? I prefer the bottom. Sorry, that's not what he said. I'm a bottom. No, that's not what he said. Bottom is probably in the 250 range. Depending on the age. Oh, God. Lemoyne, no. No. I think our lowest one was probably 5 or 6 years. No, God, Lemoyne. Have a seat. Have a seat. Now, wait a minute, Sean, no! Where's Ralph when I need him? And the top was probably 350 to 365. The top was 350 to 365. What was the hourly rate of the associate that you put on this case? Which one? Specifically, Mr. Minchell. So Mr. Minchell is 345. So 85 an hour higher than the top rate you found in Tarrant County? In Tarrant County, yes. Well, no, that's not true. With Jackson, Walker, and Haynes and Boone, the attorneys are the same as Mr. Minchell. You asked me for the bottom. And I gave it to you. Actually, I asked you bottom to top. You said the top was 350. Oh, then I was wrong. Rip Lemoyne. The top for an associate in Mr. Minchell's range at Jackson, Walker, Haynes, and Boone is going to be comparable, but that is the high end. For instance, a 2,000 up third year at Jackson, Walker comes in at 365. Now, when did your firm file notice of appearances in this case? The day I took Mr. Mignogna's deposition. Had your firm been working on this case prior to that? Yes. Approximately when was your firm retained? The first retained or billed? Retained would have been in April. I think billed was in April as well if you look at Exhibit 2. How many hours did you spend in the actual deposition for Mr. Mignogna? So that would be, we started at 9. I would have showed up about 8:30. Well, actually, it started late. I would have showed up for it about 8:30 or 9, and we, I think, left at 5:30. So there was a lunch hour? There was. And breaks in between as well? There were. Would it be a fair statement to say it was just under 6 hours? I mean, you could look at the deposition transcript and it will have the actual time on it. So if I was to represent to you that it was just under 6 hours, I wouldn't disagree with that at all. We could look at Exhibit 6 that you didn't want in, and it will tell you how long it was, says Chup. Yeah, too bad. No, we can't. We can't look at Exhibit 6 because you didn't want it in. It's not admitted. You sustain the objection. Your Honor, that would be fine. Oh, well, there you go. As part of your billing in May and June, there are various entries. In looking at the June bill specifically for now, for the preparation of Mr. Mignogna's deposition, in fact, in looking at this, over 60 hours was spent preparing for Mr. Mignogna's deposition. I don't know if you are correct. If you are representing to me that that's correct, I'll accept that representation. Is it unusual for you to spend 10 times the amount of a deposition to prepare for a deposition? A good question, right? Yes, of course. Especially when you get a shot at a plaintiff in a defamation case and he goes first. That's a kill shot opportunity. Lemoyne wouldn't know this. He's never actually had it done, right? So he's making this up. I've never had this. I've never seen it before in all my experience. So speaking to that, you said that the plaintiff was offered. Who noticed Mr. Mignogna's deposition? Well, I'm mistaken. Mr. Erickson noticed him in response to the filing and the discovery. So Mr. Mignogna's counsel did not offer him up for deposition? Oh, did Lemoyne lie earlier? I mean, he was mistaken. He's an expert. He's versed in every fact of this case. That's correct. He allowed him to be. Yeah. Have you ever made any public statements about this case? Tweets? Well, I tweet all the time, but I wouldn't call it pubic because I have to keep my Twitter closed because of all of Mr. Mignogna's friends. Thought he doesn't have any friends because he's libel proof, you lying cuck. Object is non-responsive, Your Honor. Overruled. Have you issued any tweets regarding this case? Some, yes. Have you ever tweeted specifically about the GoFundMe? GoFundMe! Sorry. It's very anime-ish with the 2 G's. All the time. Have you ever made any tweets stating that your goal was to go after the GoFundMe account as part of your attorney's fees and sanctions? No. Objection, Your Honor. Best evidence. Overruled. What were the tweets you made regarding the GoFundMe account? When? What was the first one? I have been tweeting the amount for over a month. How much is the amount to your knowledge at this time? I believe it is $261,700. Up. You know what that's time for? That's a GoFundMe time. Let's, where are we? 1 second. That's a GoFundMe. Oh, no, it's not there. Hold on. I've got it. There we go. Here is the GoFundMe. We're at $267,275. Here is the GoFundMe. You can check it out. Oh my goodness. Thank you to Michelle Moore, not Michelle Less, CC Stevens, Tony Romero, Marc-Andre Boucher, Gerant Sinjari, Anonymous, Bristol Burns, Jason Lippert. I think we might have read these. Kenneth Donaghy and Bristol Burns again. And Eddie Bush, Nikki Engler. Thank you all for your support to the GoFundMe. I have a feeling we're going to see this GoFundMe pop up a couple more times on stream. If you are wanting to have your name read, one way to do it is to just go ahead and contribute. That'll do just fine. That's up to you, though. That's up to you. I'm waiting to heavily promote the GoFundMe until appeals move along a little more fully, personally. So within just a few $1,000s of the total attorney's fees you're claiming? No, you were off by about 20,000. Within 10% then. If your math is right, sure. In reviewing your invoices, I mean, can you not figure out that 10% of 280,000 is less than 20,000? Or is that 20,000 is within 280,000, 10% of 280,000? I don't know math. I don't know. In reviewing your invoices, you mentioned earlier that the court, the Supreme Court, and the Rormuz case requires that the analysis be for the... Why does he say that? Be for the work to be both reasonable and necessary as it relates to the fees being billed. To the number of hours. The number of hours? Yes, correct. Is it also true then that it has to be necessary to the defense of the case or the prosecution of the case? Yes, that is how the statute reads. So on October 4th, just take for example, okay, hold on a second. So you're Exhibit 3A? Exhibit 3A. Gotcha. On October 4th, it's the fifth entry. It states 2.6 hours. Research and analyze cases concerning sanctions in context of bad faith mediation. Review and analyze rules and cases concerning statutory deadline for ruling on TCPA motion and analyze order granting TCPA motion to dismiss. What is it you're looking at? Good job following along, Chup. They said 3A a couple times each, but that's fine. 3A, Your Honor. What page? They're not marked with page numbers, Your Honor. Maybe get the vodka out of the water bottle, Chup. It's billing through October 31st of 2019. Zoom out a bit. Oh. I'll do it this way. Be a bit better. There we go. Sorry about that. October 31st, 2019. Okay. November 3rd, 2019. Okay. It has a note on it that says Dragon. What is that? That is our internal name for the case. Oh, come on. Okay, guys. This case is called Dragon. Oh, God. That's short for Dragon Ball. Why don't you call it DBZ? Now, on October 4th, had this court already issued its ruling as it related to the TCPA motion? It issued it about 11:30 on October 4th. And on October 7th, 3 days later, you have a billing entry for 1.2 hours to monitor harassment and abuse of clients following the dismissal. I do, but the highlight on the left hand indicates a reduction. So we would have to look at Exhibit B to see what the reduction is. But yes. So if we go to Exhibit B real quick, on that October 4th, you're kind of trying to treat yourself as a TCPA expert. Why did you need to review cases concerning the deadline for ruling on TCPA motions if you are this expert? So here's a judge, questioning the qualifications. This is not malicious necessarily. Judge is just asking a question. Why do you need to do this? Support your argument. Well, one, Judge, that's not me. That's my associate. Aha. We have a problem. Why do we have to pay for your associate that doesn't know what he's doing when you already know it? Good question. Well, I guess the first answer is I don't already know it because we had to research it. How are you an expert? This is just the timeliness or the deadline for ruling on TCPA motions. This is 5 seconds of work. If you don't know, if you're an expert, you do know. That's the problem here. That's the Hollis versus ProPath research that we had to do because there was already rumblings from the online community, not from the lawyers on the case. He's rumblings from people who are not involved with the case is influencing Lemoyne's decision. This is weakening his position. And I think he's too stupid to realize what's going on here when he mentions the online community. Lemoyne, you spend most of your day telling the online community that they're autistic basement living incels who have no idea about law. Why would you care about rumblings from the online community? And I'm talking about Duchette here. That they were going to immediately appeal and try to shut down attorney's fees. I actually don't believe that was ever fronted. I don't believe that was ever fronted. Maybe I'm wrong. But if he's referring to me as the online community, I don't think I ever suggested that they would shut down attorney's fees by appealing prior to an attorney fee ruling. So I don't know where he's getting that, actually. I have no idea. Now, if he's referring to Law Twitter making the argument that immediately appealing would shut down the attorney's fees, then Law Twitter is stupid. And he should know this by now, that Law Twitter, frankly, is absolutely idiotic. But I think he's lying here, because he should know that this can't work, because Wick Phillips has argued this point. Let me repeat that for you. Wick Phillips argued in front of the appeals court of, I think, Fort Worth, specifically, that they could shut down the other side's attorney's fees by filing early. We covered this case on the show just last month, which is after all of this happened. We covered this case. Lemoyne knows that this doesn't work, because Wick Phillips actually argued this when they tried it and lost. So good job. Hopefully Law Twitter argued that and he based it off of that. It doesn't matter. They didn't, we know how this turns out, right? They got 50G out of the 290 or whatever they asked for. They got 50. So I just had him look at it to make sure we didn't lose jurisdiction. Why'd you have him look at it? You're an expert. You're the expert, Lemoyne. You know this. Okay. Bob Job says, Grandpa died today. God damn it. Couldn't be there when it happened. Buddy, I feel you. I was 1,000 miles away from all four of my grandparents when they died. Bought a cigar and some Knob Creek rye in his honor. Shared my first cigar with him at 13. Didn't get to share a whiskey. Please pray for my family, y'all. Cheers, Rackets. Hey, Bob Job, this is Knob Creek. It's not rye. This is Knob Creek bourbon. And I will finish the glass in honor of your grandpa. Peace, buddy. I legitimately and forthrightly pray for you and your family. May you find peace and comfort. May you remember the good things and the good stories. And from personal experience, don't focus on the failings of your grandparents. Don't focus on the failing. To you guys out there, this is my personal advice to you. Don't focus on the failings of your grandparents. Don't focus on the failings of your parents. They always did the best job that they could. That's just a logical necessity. And focusing on their failings will kill you. Focus on the good stories. They failed as people and they failed in love for you. So now, I mean, unless they molested you or something, obviously that's a different story. But you know, I mean the 99% of the population whose grandparents were there when they needed them. 99 is probably generous, but you know what I mean. Grandparents are special. They don't have to deal with your bullshit while you're growing up the way your parents do for most people. So they deal with you in love in a way that no one else can. So don't focus on their failings. Focus on their strengths and focus on those good stories. All right. All right. Okay. Back to, oh wait, no, Mithrin Emrys says, well, of course they needed to spend hours and money to worry about an appeal filed by a party not involved in the case. Makes perfect sense and isn't shady in the least. Yeah, of course. Of course. All right, so back to Martinez says, looking at this invoice, going back to the October 4th time entry, is there any way for the court to determine how much time was spent identifying that statutory deadline for ruling on the TCPA motion, or was this a block note? They're all block notes. So under your understanding, you testified that you're an expert on fees. Uh-oh. If things are included in the bill that should not have been passed on to the other side needed to be segregated, for example, and the fees are all block billed, is there any way for the court to determine and to parse based on the information provided how much to allocate each individual? Well, if you have to have a segregation and analysis, no, there is not. So reviewing or portraying yourself as an expert and having someone review what a deadline would be on there to take theoretically 2.6 hours. Guys, this piece of shit is billing $365 an hour. He is charging $900 to research something for an expert that the expert should know. Let's put this in real terms. It's really simple to forget the difference between hours and fees and all that. This guy, Lemoyne, an expert on fees, an expert on the TCPA, self-professed, testifying today as an expert with several years' experience, is alleging that he sent an associate attorney to spend $900 of Monica Rial and Ron Toye's money. Monica and Ron. How many universal remotes could Ron buy to beat you with, Monica? Just think about that. That's 2.5 Logitech Harmony remotes right there. Those are the big ones. Those are the weight. He can really put that into your jawline. Think about it. Think about how many Harmony remotes he could crack across your face. For that, this is $900. For an answer he should know. So he sent an associate who shouldn't know, as not an expert, even though he does, to research $900. What could you guys do with $900? What could you guys do with $900 that's better than finding out an answer that Lemoyne should know? How do we determine, or how should the court determine what, if any, of that 2.6 hours should be allocated to that? Well, first of all, that's not all he did. Sure, Lemons. So I reject the premise of your question. But if you want to know the amount of time that it took him to figure that out, I would say it probably took him. I asked, shut up, Lemoyne. I asked how should the court, what information does the court have in front of him at this point to make that determination? Does the court have anything available to him based on the testimony you provided and the documents that you provided to make that determination? No, the court has to determine whether or not the 2.6 in its entirety. Objection, non-responsive, Your Honor. Overruled. So looking at Exhibit B to your declaration, this is invoice number 106647. I'm sorry, 111790. Okay. You said October 7th has a reduction. How much time did you reduce? I reduced it by 0.5. So can you explain to the court how monitor harassment and abuse of clients and research and analyze availability of sanctions? How did you determine exactly that specific reduction? Because I have an idea of how much time you should spend on researching and analyzing availability of sanctions. I have lots of experience in analyzing things. So your testimony is that you have an idea of how much time he should have spent? Yes. Do you have any firsthand knowledge of how much time was actually spent? No. So at least as it relates to this October 7th block bill, you have no knowledge of how much time was actually spent out of this 1.2 hours monitoring harassment and abuse versus researching and analyzing availability of sanctions. No, that's why I did a 0.5 reduction. I have no idea how much, so I just picked a number. Now, does the TCPA have any language in it related to the award of sanctions pursuant to the granting of a motion to dismiss for TCPA? If I understand your question correctly, 27.009, I think it's B is the sanction component and A is the fees component. So TCPA expressly states that sanctions are available? Yes. So it's your testimony that a reasonable and necessary fee under, at least as it relates to this November 7th deal, is 7/10 of an hour to determine whether sanctions are available when they're expressly spelled out under a statute that you claimed you're an expert and that you blog about? Oh, gosh. Sorry. No, that's not what I'm saying. That's not what he's researching. He's researching, it's stating what is available in this context. The research states, research and analyze availability of sanctions. Yes. So the document speaks for itself. If you are researching the availability of sanctions and the sanctions are expressly allowed under the statute, how is that a reasonable or necessary expense? This is an excellent question. Martinez is asking very good questions here. Because he's not researching whether or not the statute says sanctions are available. He's researching specific cases. So your testimony is that you know what he did as opposed to what he documented that he did. Well, I told him what to do, so yes. So the documentation is inaccurate? Well, no. No, you were just reading it inaccurately. Could you read everything after the semicolon? Prepare to have your colon evacuated, Lemoyne. Research and analyze availability of sanctions. Sanctions are available under TCPA, correct? Yes. Thank you. Monica and Ron, you paid $310. I think. What's 365 times 0.7? 365 times 0.7. Oh, sorry, $255. Lawyers don't do math. We're not engineers. $255. You paid $250 to find out if you could do sanctions in a TCPA if you'd get them. Lemoyne knows you get them. By the way, so does Minshall because Minshall isn't an idiot. Monica and Ron, this mother effer, this soft A billed you $250. He sent you an invoice for $250 to tell him what he already knows is in the statute. T. Greg Doucette hasn't made $250 in a year from a client, and this motherfucker billed you $250 to tell you if sanctions were awarded under the TCPA. I would have done it for a $3 super chat. Oh. I would have done it for someone else's $3 super chat. Oh my gosh. All right, back to it. Sorry. He charged him $250 for just reading the statute. On October 29th, the next page, page 4 of 5, same invoice. You have, and this is another one that was reduced some, so we can check that. Draft and revise motion to compel Slatosh deposition. I'm with you. Lost Bullets says knob is probably Lemoyne's favorite thing to put in his mouth. Come on. Come on. And Siren Jack says, Lemoyne is so good at analysis that you can insert your credit card into his anus and he can read the 16-digit number, the expiration date, the 3-digit code, the bank, the payment processor, and the magnetic stripe. But does he know the zip code? Not quite. Not quite. That's an extra 1.5 hours. I'm with you. 3.6 hours, correct? That's correct. Can you look at Exhibit B? You said anything with a highlight is reduced. I missed a reduction. So there was no reduction? Oh, I misspelled it. 1026 is 1029. There's no highlight for 1026 in Exhibit A. There's no entry for 1026. That's correct. I fat-fingered the 6 instead of a 9. Are you sure you didn't have the Irishman from My Left Foot typing up your document? So the document was not accurate. When you say you fat-fingered the 6 as a 9, I guess you're talking about a keyboard? Right, I'm on the keyboard and I hit a 6 instead of a 9. Them some fat fingers, bro. He must type his numbers on the 10 key, right? Because otherwise, that is 5 or 4. That's 4 keys away. 3 keys? Guess if you count the 9, it's 4. If you don't count the 9, it's 3. That's a fat finger. Oh my God. Okay, I gotcha. Thanks, Chup. And so, you're right, it is inaccurate. There's no invoice entry for 6, and there is a highlight for 29. Now, going to specifically the work that was done that day, the purpose of the attorney's fees are to prosecute the case itself. The deposition and the motion to compel, redact, and revise the motion to compel for the deposition. This court, as it sits so far, has determined that that was an improper discovery request. Objection, Your Honor. That mischaracterizes the... I don't know if that's what I said, but I didn't grant his motion. The court granted a motion quashing the deposition for protective order. Protective order? That's correct. So in that regard, any work related to that which was done after, we would contend after the close of discovery, how does that further the prosecution of the TCPA case? Well, it furthers the prosecution of the sanctions component. I mean, we lost. Self-awareness from Chup from Lemoyne that doesn't exist on Law Twitter. We lost, but that doesn't mean that it wasn't reasonable and necessary. How much did you reduce that for that specific entry? 1 hour. I'm sorry. 1 hour. 1 hour? You made mention of looking at what Mr. Rekieta allegedly has been doing online. You said he has a blog. Do I have a blog? I haven't had a blog since 2007. 2008? I guess he's reporting things. Is that what you said? He has a YouTube channel, but I wouldn't call what he does reporting. I mean, lemons. Lemons. What else is it? Bringing information to people who don't have access to it. Or don't have easy access to it. Let's see. Canabian says, can't wait till we get to the I thought you were an expert though section. It's coming up. So did your firm ever take any action or file anything related to Mr. Rekieta or try to depose him to try to... Yes! What did your firm do? We filed a motion to... Well... We filed a notice of intent to subpoena. Before we ever even served the subpoena, it was quashed. In response to the motion to quash, we filed a motion to compel discovery. And where was that done? Here in Fort Worth in this court. Okay. And then we never got it set for hearing because the TCPA stay was in effect. And part of that motion was a motion to determine if the stay applied to us because we had not filed a TCPA motion, which is a gray area. And then we just ultimately decided not to pursue it at that time. It's a gray. You say it's a gray area. Are you saying that there's no case law related to that at this point? There's no case law that discusses when Mr. Volney at Funimation files a TCPA motion. Does that automatically prevent all the other defendants who did not file it, who are being sued by the plaintiff, meaning that case won't be stayed if there's a denial, or the action still lie between parties that don't have a TCPA in place? I actually think he's wrong here. I think there is case. I can't cite it. I'm not the Texas TCPA expert. So maybe he wins on this one. But I think he's wrong here. I think there is case law on point in Texas stating that once any TCPA is filed, all discovery in the case is stayed. I don't know that for sure, but I think so. Who knows? The expert is a cuck, so we'll never know. Michael Decay says, as Lemoyne, okay team, the super secret code name for Vic case is Dragon Balls Across the Lemon Face. Sorry. Oh, I love it. Scrotal enjoyment. Sorry. Okay. So to the best of your knowledge, no court has ever considered that question? To the best of my knowledge, no. I could have missed something. There is over 400 TCPA cases. There are, Lemoyne. There are over 400 TCPA cases. On invoice number 110397, what's the date? Invoice through September 30th, 2019. Okay, what page? Page 1. Okay. Specifically September 17th, 2019. Yes. Can you read everything after the semicolon? I can read. All right, I read it. Can you read it out loud, please? Listen to it. Look at him. This is a funny lawyer deposition or examination answer. I read it. Got ya. You know they're gonna fall. I almost wish Martinez would have not made him read it out loud. I almost wish Martinez would have not made him read it out loud, specifically because of, thanks. I just wanted you to know it because I think you're retarded. Something like that would have been great. Can you read it out loud, please? Oh, I'm sorry. Prepare for and attend hearing with client. Pursue strategy, remediation, and D. Seidler confer death threat issues. And who is JSL? That's me. Now, Mr. Lemoyne. It's Lemoyne. Okay. Inside baseball. If you don't understand what happened here, Martinez called him Lemoyne. His name is Lemoyne. So I'm going to read it the proper way. Now, Mr. Lemoyne. It's Lemoyne. I'm sorry. It's Lemoyne. Lemoyne. My apologies. Okay, I know you're not doing it on purpose. Oh, no. My apologies, sir. You also reduced this invoice. Can't take it. What was your you also reduced this invoice? I did. By how much? 1 hour. What was your reasoning for reducing it by an hour? Because me having to deal with the death threats that are caused by what is being said about the case outside the courtroom has nothing to do with defending the TCPA motion, so I can't pass it along to your side. So dealing with things that happen outside the court has nothing to do with death threats outside the court. Have nothing to do with this? Death threats, yes, but dealing with things outside, no. In general, I wouldn't agree with that. Now, on the same invoice, page 2, September 30th. Yes. EAM, the fourth line down. That's a redaction. It just states client communications. Prepare for mediation. Yes. Would you agree with me that one of the requirements the Texas Supreme Court has laid out is that although you are allowed redactions, the details within the bill still have to be sufficient for the court to determine whether that specific activity is something that can be billed? I don't know if the Texas Supreme Court has said that. You're an expert on fees and you don't know? But I would agree generally with your legal proposition, yes. I would also agree with your marital proposition, please marry me. So from that perspective, if you agree generally with that proposition, how, if you redact everything other than communication, can the court determine that billing entry is pursuant to furthering the TCPA? There's two ways. One of the ways is on some redactions, because of the redaction, I make a reduction, and you'll see that on some of my line entries. That is not on this one, though, correct? You're right. The other way is we brought the unredacted version so that we could submit it in camera. That means the court gets to review it. To the extent you're raising that issue. So we have brought the unredacted versions, and the judge can review them and can make those determinations. You talked about it a couple of different times, and you pontificated, I guess, that Mr. Rekieta was a target of your review as it related to this case. Or you researched and watched videos from Mr. Rekieta because you felt that he was somehow involved. Am I characterizing your testimony correctly? I watched Mr. Rekieta because he tells us what the plaintiff's legal counsel is thinking. Otherwise, I would not watch him. That's amazing. Think about this. Lemoyne is giving me, a lawyer journalist in Minnesota, commenting from the outside about the case, is giving me so much credibility that he thinks that what I say is what Vic's lawyers are thinking. I barely say what I'm thinking half the time, because I would be thrown off of YouTube in a Lemoyne ejaculation minute. Oh my God. Why on earth would Lemoyne suggest that what I say is what the defense is thinking? That's the stupidest conclusion you can come to. So, Mr. Rekieta has no connection. It's your opinion Mr. Rekieta has no connection formally to the case? Is that correct? No, that's not my opinion at all. I think he's Mr. Beard's agent. I think he's Mr. Mignogna. Do you have any evidence whatsoever to establish that? Yes. Oh, citation effing needed. Has it been placed before the court already? No. Well, I mean, yes, but not in this hearing. So you say yes, but not in this hearing. Prior to this hearing, what evidence has been admitted by the court that would establish that Mr. Rekieta is an agent of Mr. Beard? Now, in case you're wondering here, agency is a very specific relationship. That means that I act on behalf and in the interest of Mr. Beard. If I am Ty Beard's agent, there is a lot that goes into it. Typically, to establish an agency relationship, you have to have an admission of agency from me and an acknowledgement by either words or some affirmative conduct of agency from the principal, who would be Ty in this case. Now, in this case, you have consistent denials of agency from both me and Ty. This is one of the worst legal arguments ever. So first of all, not only does he have to argue agency over our overt statements that I am not the agent of Vic or Ty, and over Ty's overt statements that I am not the agent of Vic or Ty. Okay? You have to argue over that. But second, you would then have to overcome that presumption with overwhelming, specific, and direct evidence to the contrary, and allege that not only are we lying to the public, but that Ty has lied specifically to the court about this. That is balls. Whatever Lemoyne has, now they may be in his mouth, but that is balls right there. That is insane. This is insanity. If you want, the definition of insanity is doing the same thing over and over. No, the definition of insanity is Lemoyne asserting an agency relationship that is denied by both the agent and the principal and lacks any direct evidence to the contrary, and would require two lawyers to lie in public, which would be to risk both of our bar admissions and to risk severe sanctions against Ty Beard in the case and potential financial implications against me. Like, I don't think you guys understand. If Ty and I were to be lying about the agency relationship here, to be lying about it, we would be incurring hundreds of thousands of dollars of personal financial risk and a destruction of our careers. Potentially criminal perjury charges as well for Ty. I haven't been before the court. I haven't testified under oath, so that's not going to happen. That is where this is what Lemoyne's alleging. Make no mistake. So this is the seriousness here. Not just they're kind of No. This would be perjury for Ty, public lying for me, which would be conduct unbecoming of an attorney outside of a thing. To lie publicly about a significant fact in an ongoing lawsuit in which, by the way, if I'm an agent of Ty, then I would be on the defense counsel or the plaintiff's counsel and would then be potentially, I would be in violation of candor to the court and all of that stuff. Like, I would be violating, if I were an agent and I were disclosing things from an agency relationship that I should not be disclosing, as they're alleging, I would be violating all sorts of ethical rules. I would be I would be civilly liable to my principals. Like, this is insane. This is legitimately stupid. Lemoyne, get help. Lemoyne, get help. Your legal argument here is so bad that even Minshall wouldn't have made it. All right, back to it. Well, I don't know if you would call it an agency relationship, but we have admitted that. So there is no evidence whatsoever that has been submitted to the court and admitted by the court that Mr. Rekieta is an agent of Mr. Beard. I think that's fair. So your statement of your belief that Mr. Rekieta is an agent has no foundation whatsoever as it relates to at least evidence that's been submitted to the court. If you're talking about evidence introduced to the court, yes. I guess I'm going to say yes. Martinez annihilated Lemoyne on that line of questioning. Absolutely annihilated him on it. Ricky, intern Chan. Today was a good day. Got the keys to my new house, which means no more crazy paranoid landlord. Oh, that's great. That's great. Ricky, I miss you. I hope to see you at a convention this coming year. That'd be great. All right. Yet, despite the fact that there's no evidence that's been submitted to the court showing that Mr. Rekieta is an agent or has any other connection whatsoever to this case, by the way, I'm not an agent and I have no connection to this case. I'm not an agent of Vic. I'm not an agent of Ty. And just try and find them saying, yeah, we get to control what Nick Rekieta says. Good luck. If either of them told me what to say, I would probably say the opposite immediately on principle. I don't deal well with authority in general. It's why I run my own firm. It's why I have my own YouTube channel. It's why when people tell me what to do on my YouTube channel, I typically do the opposite. It's not going to go well for anybody here. You are billing, for example, July 3rd, 2019, in the July bill, and another one would be the time that you filed the motion to or the attempt to subpoena Mr. Rekieta. Your bill is replete with things that are attempting to charge as reasonable and necessary attorney's fees, review of things or research into things, background research specifically on July 3rd into Mr. Rekieta, and you are attempting to say these are reasonable and necessary fees? Objection, compound. Overruled. If he can't understand a question, he can ask him to rephrase it. Yes. And your testimony is that furthers that researching a third party who has no connection to the case, at least as it relates to evidence submitted to the court, is a necessary fee for prosecuting a TCPA motion. I disagree with the internal predicate that you're making, which is that it has to be submitted to the court to be necessary. The fact that I haven't submitted evidence to the court doesn't mean it's not necessary to the defense of the case. Throughout your billing, there are various examples, and Your Honor, if I may, I'm not going to point to the court to each individual one. I'll simply represent that there are various examples of times where you coordinated or conducted phone calls and things like that with other defense counsel outside of your firm. That's correct. I should drink more whiskey? Probably not. Which is why I will pour another shot. We're coming up to the... We're going to come up to the end of the show before too long. We're on page 60. I'm going to try and get to page 80, so we're halfway through. But I'm going to need to take a bathroom break in a minute. And probably get another drink, because here goes the last of the Milos. Now, my cough medication said don't take with liquor because it makes you drowsy. Shill the merch I updated with a promo code. I will. I'm going to go to the bathroom and I'm going to get another non-alcoholic beverage to help with my throat. And then we're going to go to page 80 tonight. That's what I've resolved. Page 80 will be the stopping point. Otherwise, it's going to be like a 6-hour stream and I can't do it. So let me put the merch. Put the merch up here. Okay, here we go. Hold on. Oh my gosh. Why can I not? Are we serious? Why can't I make the window was not. Anyway, never mind. It's me being a boomer. Somehow it's my fault, I'm sure. All right, so here is the merch. The Grift Law-splaining logo. First 24-hour bonus, free shipping with promo code GRIFT. Lasts until January 5th. If you're interested in picking up one of these shirts, go ahead and do it. I'm going to run to the bathroom. You can find the link in the description. You can also find the link in the chat from Tillip. I'll be right back, guys. I'll be right back. The description says, this is a complete retraction or recreation of the original show logo. Nothing special. Well, that's actually not true. Everything in this listing is not only more expensive, but also features darn near every possible item you could stick a logo on. We got classic tees, comfort tees, women's, premiums, tri-blends, hoodies, tank tops, baby's clothes, leggings, socks, phone cases, mugs, a tote bag, stickers, blankets, tapestries, and even a beach towel. Every possible size and color, even colors where the design looks freaking terrible. Why? Grift. So check that out if you want, guys. I'll be back in just a moment. Chair Coon will tell some jokes for the stream, and I'll be back in just a second. That was not my door squeaking. That was actually just Lemoyne reeing in the distance. Okay. Back. Sorry for the delay or for the thing there. All right. Now the grifting is done. Get back to I have these eye drops. I don't know if you guys do eye drops. I'm trying to start doing eye drops because after I do these shows where I stare at a computer screen for like 8 hours right before going to bed, I wake up and my eyes feel terrible. So, let's see. All right. Now let's get back into it. We've got Dirk Lemon says, "Hey chat, check out this very exceptional channel called Cop Bait. It's amazing. He even puts his face in these videos. Nick, can you please play just one of them on stream for a minute or two? How do people become sovereign citizens anyway? Not on this stream, but I will look at it. I will look at it, Dirk." Claymore One says, "My family going to the Philippines sometime this month. I asked for a souvenir from Duty Free for the Lambanog drink that you can try from our homeland." Oh, that would be awesome. That'd be awesome. Okay, here we go. "My chair is racist and anti-Semitic, but my chair's black. It can't be racist. Liar." All right. Let's get back to these. So this is, again, in response to conducted phone calls and things like that with other defense counsel outside your firm. That's correct. The details of which were, from what I was able to gather here, putting together a strategy on how to move forward and things of that regard, and trying to, I guess, compare notes, so to speak. Is that a fair statement? Are you ready for an answer? Are you ready? Like, what a weird... Are you ready for an answer? Yes, sir. The answer is yes, in part. One of the requirements under the RORMUs is that there's no duplication of efforts. Yes. Or that the duplication is limited. Yes. Duplicative efforts is something the court should consider in reduction. Yes, that is correct. So in this instance where, for example, you would work with opposing counsel to duplicate efforts and research and things of that regard, should the court consider that as part of its reduction? No, because it's the opposite of duplicating efforts. It's to not duplicate efforts. So rather than each counsel independently determining what they need to research, they had a long meeting and then they all went and independently researched it anyway. That's not duplicative at all. Okay, speaking of duplication fees, on June 26th, the deposition of Mr. Mignogna. Who attended that deposition in person? Me, Mr. Eric, on behalf of Ms. Rial and Mr. Toye. I'm sorry, from your side. Yes, Mr. Minshall was on video. It was transmitted through the internet, so he was there. The internet is Al Gore taking a piece of paper and running it across the country. So Mr. Minshall on video was billing 9 hours or 7 hours to watch the deposition. Of course, the problem with having someone on video on a stream deposition is, how do you know they were actually there? Are they on the transcript that say Mr. Minshall via video conference for the defense? I don't think so, actually. That's correct. So Mr. Minshall was on video billing 7 hours to watch the deposition. That's correct. How did that add to the presentation of the deposition when he wasn't even in the room? It didn't. So that would be duplicative, would it not? Well, that's why I reduced it by 4 hours. So 3 hours is not duplicative, though, to watch it. It doesn't add anything. So 3 hours is okay, but 7 isn't? Yes, but you'd have to ask what he was doing. I'm sorry? You'd have to ask what he was doing and why I was billing that. Again, this is something Lemoyne shouldn't be saying. But Martinez is about done. So he passes the witness. I'll pass the witness, Your Honor. And then the court goes back to Helberg. So this is redirect. Redirect has similar rules to direct examination, and that there's no leading questions, but it's similarly limited. You can't bring up new stuff on redirect. You can only address things that came up during cross-examination. Okay? You're not bringing up new stuff. Do you have something you want to ask him other than new stuff? Yes, Your Honor. Okay. What was he doing? What was Mr. Minshall doing? He was sending me notes throughout the deposition of things that I was missing and documents that I needed to pull out in areas of the case that Mr. Minshall knew much better than I did at the time. This is suspect, right? This might be. They don't object to it, but this might be questionable deposition stuff. Sitting there, basically, Mr. Minshall could be sitting there with the entire internet at his disposal, researching things and sending questions to send into deposition. Responding to Vic's responses in real time, stuff like that. With respect to the fees that you are seeking here and addressing the points that were raised in cross, does that fall within billing discretion? Yes. Was what you did correct? Yeah. Did you exercise billing discretion when you submitted the prior testimony? Yes. I passed the witness. Nothing further from Martinez. Court, how many depositions were taken? 3. How many hours was that approximately? Well, were they all 6? I would assume so. I didn't attend the others. Okay, so maybe 18 hours of depos. How many things of substance have you actually filed with the court? You filed an answer, which is probably not a big deal. You filed a motion to quash, which isn't really a big deal. So Chup is a former trial attorney, right? Like, let's point this out. Chup knows how much an answer costs. An answer is like an hour, 2 hours of work. Motion to quash, much more than an hour, 2 hours worth. Like, motion to quash, if you're billing an hour for it, motion to quash is literally, if you file it within 3 days, you get it. You get it 99% of the time. And then they have to challenge it and then have a hearing. And then you get to make your arguments at the hearing on the motion to quash. But it's really simple. It shouldn't even be an hour. Which isn't really a big deal. You filed a TCPA motion to dismiss, and I appreciate that one. That's a real motion. What else did you file? There was a supplement, and then we had to file, if the court recalls, the binders we sent that before the hearing. It was like 4 different binders. Yes, you had like evidence and stuff from the internet, right? Right. Well, no, sorry. Yes, but that was in terms of what did you file? So there was the motion itself to dismiss, the supplement. Then we had to file a reply. Then we were responding to all the objections they lodged to our evidence, all the evidence we lodged against theirs. You had the notary fraud issue. You had the new anti-slap or the new pleading that they filed, the second amended petition 3 days before the hearing that we had to deal with. If I give you 0 money in attorney's fees, are you going to make Miss Rial pay you $282,000 for basically, 6 months of a lawsuit? Valid question. Yes. Whoa. And you are charging $435 for someone who doesn't know much about TCPA to work on this case that he's got to go look it up. That seems kind of high. It doesn't really seem worth it if he can't do it without having to look everything up. Well, not to anger the court, but he wasn't looking up the statute to see whether or not sanctions were available. He was reading cases about the fact pattern because it was, are you calling another witness here? Me? Yes. No. So you've got no evidence of anything with regards to sanctions. Oh, am I? What part do you not understand about are y'all calling another witness? I didn't know if you were talking to me or Mr. Volney. I'm calling Mr. Mignogna. Yes, Judge. All right, you can step down. All right, so we get to Mignogna's testimony here. Why don't we take a break? David has to be somewhere at noon, and let's be back. We'll start back at 1 o'clock. I don't know who David is. Your Honor, at this time we call Mr. Mignogna to the stand. So Vic comes in and is sworn. Now, put in your mind's eye, voice actor Vic Mignogna. You can make your own judgments about his looks, his demeanor, his voice. His voice. Hi, I'm well, Your Honor, I'm Vic Mignogna, a voice actor. I was one for Funimation and Rooster Teeth and Sentai and a couple other places. Right? You make your own determinations. I'm going to say they're going to good or bad. Doesn't matter to me. You make your own decisions about Vic. And you make your own decisions about Lemoyne, their presence, sounds of their voices. You can hear them both at the deposition videos. Specifically, Vic's deposition video, you can hear both of them. This is the contrast that is before the court. Not the con slut, the contrast. Lemoyne just sat there for a while, wheezing at the judge. A long while. It's 1 o'clock now. So now Lemoyne is going to question Vic. And again, that contrast is going to be evident. I think this is a mistake. Helberg should have questioned Vic. Or they could have hired a pretty chick to question Vic. Why in God's name they haven't had Andrea Perez questioning Vic this entire time is beyond me. Is beyond me. Maybe she's bad at cross-examination. I don't know. But they should have Andrea Perez doing it. Here we go. Would you state your name for the record? Victor Mignogna. Mr. Mignogna, how old are you? 57. Would you turn to Exhibit 8? I'm not going to do Vic's voice the whole time, sorry. And it's also going to be on the screen in front of you. Okay. This is the lawsuit that you authorized to be filed on April 18th, 2019, isn't it? Literally, this ninja is putting up PowerPoint presentations again. Again. He didn't learn from the TCPA. Chup doesn't like PowerPoints. Doesn't like them. Doesn't want to see them. Especially when they come from Lemoyne. This is a lawsuit that you authorized to be filed on April 18th, 2019, isn't it? I guess so, if you're saying so. Have you ever seen the lawsuit that you authorized your attorneys to file in this lawsuit? Do you mean have I read through it? Yes. No, sir. So you didn't do anything to verify the facts in the lawsuit? I trusted my attorney. Judge, at this time, I would move to admit Exhibit 8 into evidence. Now, interestingly, Exhibit 8, if it weren't already filed in the case, it'd be kind of tough because Vic did not verify this document. Vic specifically, I don't recognize this document, right? Like he's saying here, I haven't read through it. He can't verify the accuracy of this. Now, the only reason is if Exhibit 8 matches the prior pleading, then it's not a big deal. But he didn't properly lay foundation for Exhibit 8. They could have objected to it. Except for the court. I assume it's in the file. It's part of the file. Yes. So in this case, it doesn't matter. If this were any document on earth other than like the pleading, Lemoyne didn't properly lay foundation for this document and would have gotten blown out on any objection to it. Okay. Okay, it's admitted. If you would turn to Exhibit 9. And Your Honor, at this time I would ask the court to take judicial notice of the dates in which the various conventions were canceled in the first amended petition. These are the dates that are listed in the petition? Yes, sir. Okay. Nixek says, do law firms often have enough self-awareness to strategically pick the right person to do a deposition, a la Andrea Perez over Lemoyne deposing Vic in this case? Yes. Yes. They can go about it a couple different ways, right? They could say, well, we have our deposition guy. Or they could say, or we have an asshole. That's Lemoyne, right? Make no mistake. They picked a guy who would be unpleasant to listen to at deposition and who would have no trouble treating Vic like a piece of garbage. That's what Lemoyne's job was at deposition, was to be a prick. And he does it really well. It must come naturally to him or something. But I still think that's a miscalculation. Because if you've got a guy, now put you in charge of a law firm or a lawsuit. I don't care if you're in charge of the whole firm, just a suit. You've got a guy who you are going to accuse of being traditional. Because let's make no mistake, okay? Whatever you think of male-female interactions in 2020, throw that out. Throw that out right now. Think of male-female interactions 30 years ago. All right? Let's go back to the 90s for just a second. In your mind, not in reality, in your mind. In the 90s, can you honestly say, would a single allegation against Vic in the 90s, given who he is and the relative questions, would any of this ever see the light of day? No, not a chance. Because if you look up literally any rock tour in the 80s and 90s, this behavior from Vic that he's accused of, the worst stuff he's accused of, is absolutely tame in comparison, okay? Think of this. This isn't relevant to the legal analysis. This is you being a big brain. So you've got a guy who you know, your specific accusations from your clients is that this guy is in the 90s. That's the long and short of this, right? Are you with me on this? Long and short of this, you can think it's inappropriate in 2020. I don't care. I don't care what you think about that. If you think that saying, hey, would you like me to put a finger in your butt? Like, if you think that is inappropriate in 2020, fine. I don't care what you think about that. Your opinion of the guy who said finger in the butt is that he lives in the 90s. That's the basis of your accusation. He lives in the 90s and the times have moved on. All right. Who do you have question? A guy, a man, an alpha, if you will, who is sexually predating on every woman in the area, even fat, ugly women like Samantha Inu Hart. This guy is so sexually overcharged in your mind that literal igloo Samantha Inu Hart walks in the room and he can't stop from sexually harassing her. That's how 90s Vic Mignogna is in these people's opinion. That he would sexually harass a fucking building, right? That is how uncontrollably sexualized he is. Now you have at your disposal, you have Casey Eric, who looks like a dwarf football player. You have Jay Sean Lemoyne, who looks like a pile of laundry. And you have Andrea Perez, who is actually pretty. You have those three options at your disposal. And you pick the pile of laundry rather than a pretty woman who could, in theory, completely disarm man with archaic brain. Why on God's green earth would you not have Andrea Perez do the deposition? This is the dumbest play. I don't care. In your mind, he probably would have hit on her in the deposition. Oh my God. All right. Okay. Mr. Mignogna, looking at Defendant's Exhibit 9. I'm going to represent to you that the dates under those with regard to the various conventions are the dates that your lawsuit says those conventions were terminated. Are you with me? Yes, sir. All right. Do you agree with that? I assume that's true, yes. Okay. As we sit here today, when this lawsuit was filed on April 18th, 2019, did you believe that all four of the defendants had interfered with each convention that is listed on Defendant's Exhibit 9? Now notice what he says. I had no direct evidence of that. Shane Helberg made a lot of noise about this. He doesn't have to have direct evidence at this point in the trial. He has to have evidence, but remember how the TCPA defines evidence. Evidence in the TCPA is literally the allegations in the pleadings, if taken as true, are evidence for the TCPA. Full stop. I know, Shane, I know you're dealing with less chromosomes than everybody else. I get it. I know, buddy. I know. Direct evidence is different from any evidence. And it's certainly different from a prima facie showing. Even a prima facie showing by clear and specific evidence. I know this is hard to follow. But not having direct evidence, most people, when they file lawsuits, don't have direct evidence. That's something you get on discovery. You have circumstantial evidence, rational inferences that lead to conclusions. That is sufficient to file lawsuits. Discovery provides you with the direct evidence. That's why this exists. I know this is hard. I'm sorry that you're sub 40 IQ. Before too long, it's going to be freezing, buddy. This does not have anything to do with TCPA or its ability to survive. Shane Helberg is stupid, as usual. Not just wrong, but stupid. Okay? Direct evidence is, one, there's direct and circumstantial evidence. Two, clear and specific evidence is a specific, it's not a specific standard of evidence, but it's a specific type of evidence that's under the TCPA and for the limited purpose of the TCPA. The allegations in the pleadings, if taken as true, are evidence for that clear and specific standard. I know it's hard, but it just is. And if you think that's stupid, yes, the TCPA is stupid. It's poorly written. It's poorly constructed. It has a lot of good intentions and a lot of bad executions. I'm with you. I'm with you on that. And you can find numerous cases trying to figure out what clear and specific evidence even means because it's so unique to this law. And the Supreme Court has had to tell several appellate courts what clear and specific actually means over and over again. And when they tell them, they still get it wrong. And then they get it wrong after that. So it's not your fault that you got it wrong, except it is. It is your fault because you, Shane Helberg, are one of the stupidest individuals to ever walk the planet. And that is evidenced by you eating shoes. Okay, anyway. Did you believe it to be true? I did, based on things that I had heard. That's circumstantial evidence. Okay, I want to break these down by defendant. First defendant, Jaime Markey. Your position is that Miss Markey interfered with all 11 conventions that are listed on Defendant's Exhibit 9. No, sir. Okay, so she didn't interfere. That's not what he asked. All 11 conventions to Jamie Markey. Is there one on there that you could point to that she interfered with? No, sir. As we said today, you cannot point to the court to any one of these conventions that you contend that Miss Markey interfered with. No, sir. Again, that's fine, by the way. He can allege that she interfered with them, and that can be evidence for the TCPA. Is it sufficient to pass? Don't know. But the questions on Markey are not necessarily whether or not she engaged in the tortious interference or whether or not she was part of this civil conspiracy for the tortious interference. Those are different things. Anyway, not everybody who engages in a civil conspiracy actually engages in the elements of the underlying tort. It sounds weird, but it's true. All right. How about with regard to defendant Miss Rial? As we sit, when you filed the lawsuit in April of 2019, did you have any evidence that Miss Rial interfered with any of the conventions on this list? I don't believe this is a complete list, but the ones listed here, I do not. I'm guessing Kamea Khan's not on there, right? All right. What about with regard to Mr. Toye? When the lawsuit was filed in April of 2019, did you believe that Mr. Toye had interfered with any of the conventions that are listed on Defendant's Exhibit 9? I believe it to be true, but I have no direct evidence of that. So again, Toye, in his text messages that came out after this, by the way, in his text messages, Toye said that he and Monica contacted other conventions now, or would contact other conventions. No, not having direct evidence of that contact does not mean that you don't have circumstantial evidence and a rational inference that they did. Okay, let's be clear on this. As you sit here today, do you have direct evidence that Mr. Toye interfered with any of the conventions on Exhibit 9? No, sir. So again, I don't know what's on Exhibit 9, but it must not be Kamea Khan. Okay, what about Funimation? When you filed a lawsuit, do you have any evidence that Funimation interfered with any of the conventions in Exhibit 9? I've been given information by people at different events. They had made their decision based on Funimation's involvement. Okay, and that was Funimation's tweet, which you sued them over? That and other things as well. Okay, and you would agree with me, wouldn't? And this, of course, brings in the vicarious liability aspect of it. Who's acting on behalf of Funimation? Who's responsible for all of these actions? You would agree with me, wouldn't you, sir, that the tweet occurred on February 11th, 2019? I suppose that's true. I don't have the date memorized, sir. Okay. Scott, would you pull up Defendant's Exhibit 8, paragraph 30? Mr. Lasagna, does this refresh your memory that the tweet in which you sued Funimation over occurred on February 11th of 2019? It would appear that was when the initial tweet was made. Yes, sir. All right, Scott. Would you scroll up so that we can see the tweet? Yes. Go up. Oh, yes, Scott. I'm sorry, Scott. Move down. Mr. Mignogna, is this the tweet you sued Funimation over? I believe there was more than one. There's more than one? I believe there was more than one tweet by Funimation. What date did those tweets occur? I'm afraid I don't know offhand. Okay. And he's not required to at this hearing, by the way. I just want to point that out. Okay, if this tweet actually occurred on February 11th, 2019, like you said, you would agree with me that this tweet could not have caused the cancellation of any conventions listed in the petition. Objection, Your Honor. That calls for speculation. Overruled. But if you can't answer it, don't. He doesn't say but. If you can't answer it, don't answer it. So he overrules the call for speculation, even though it clearly calls for speculation. But he says if you can't answer it, don't answer it. Again, Lemoyne doesn't seem to like objections. Generally, he overrules a lot of them, even when they should be sustained. Did this tweet? Could you rephrase? Because I actually have an answer. Can you ask me again, please? Okay. Did this tweet cause the cancellation of any of the conventions listed on Defendant's Exhibit 9? I have no reason to believe the tweet caused any cancellations, obviously, before the tweet occurred. But there was a great deal going on social media and a lot of spiraling around all that related to the cancellations. Mr. Mignogna, you're not suing social media today, are you? You can't do that. It's impossible. Oh, did I say Chup? I said Lemoyne. I meant Chup. Oh, God. The worst insult I've ever given to Judge Chup was mistaking him for Lemoyne. Sorry. Sorry, Chup. Please forgive me. And people that incurred fees having to fight this lawsuit, that's not social media. That's the defendants, isn't it? I'm sorry. Say that again, please. The defendants are the ones that had to incur fees to fight your lawsuit, aren't they? Objection, Your Honor. It's asking whether he knows information that the defendants would be in a better position to know. It's asking for speculation on this part. Now, Chup sustains this one, which is like, I mean, it's yes, but the obvious implication is that the defendants are not social media, and people who are not the defendants are likely not the ones sustaining the fees. Even if they're providing the defendants money, the defendants are sustaining the fees. So that's weird. He sustains this one. But yeah, I guess he gets over his dislike of objections. But it's the right ruling. But it's with all of the other ones that he's let go that were also correct objections. This is weird. Mr. Mignogna, you agree with me that this tweet did not cause the termination of any of the cancellation of the conventions on Exhibit 9? Objection again, Your Honor. It calls for speculation. It's his lawsuit. Overruled. If you can answer it. If you're guessing, don't guess. There were many elements that contributed to the ultimate cancellations. Objection, non-responsive. Wait, sorry. I read that wrong. Sorry, Vic. There were many elements that contributed to the ultimate cancellations. Objection, non-responsive. Overruled. If you don't like his answer, ask his answer. Tough. You were asking a question, he's answering it. Okay, I'll try again. Sorry, Judge. Okay. Look, you asked the question. If you don't like the answer. Anyway. Pull up Defendant's Exhibit 9 for me. Mr. Mignogna. The last convention on Exhibit 9, the last convention listed in your lawsuit terminated on February 6, 2019. Explain to Judge Chup how a tweet on February 11, 2019 caused the termination of any convention listed in your lawsuit. Now, importantly, Martinez is letting him go here. But what is the purpose of this hearing? What is the purpose of this hearing? Fees. Fees. Why is Lemoyne arguing on behalf of Funimation? That's a good question, by the way. Who's the client? Who's the client? Why is Lemoyne levying an argument in a hearing about fees over the propriety of suing Funimation? Who's the client? Next. So there are a great many communications that go on that are not on Twitter. Real quick, I think what he's saying is that the tweet happened after, yes, sir, yes, sir. So that tweet couldn't have done, well, the tweet, no. The tweet could not, that's correct. That's all he's asking you. There were other factors is all I meant to say, sir. Your attorney will ask you questions. Yes, sir. Court, judge, why are you stepping in on Lemoyne's behalf? Let him fail at questioning. Imagine being rescued by the judge because you're doing so bad that the impartial judge has to come in and say like, oh my God, I know he's horrible to listen to, but here's what he's asking. Mr. Mignogna, when the lawsuit was filed against Funimation, you didn't have any evidence that Funimation had done anything to cause you to lose any of the conventions that are listed on Exhibit 9, did you? Listed on the exhibit? No, sir. Doesn't have to, by the way. Mr. Mignogna, even sitting here today, you cannot identify any convention that was canceled because of anything that Funimation did, can you? Objection, Your Honor. Again, it calls for speculation. Additionally, Your Honor, in this instance, the court granted the TCPA, so it did not allow discovery to get to the merits of the issue. If it calls for speculation, wouldn't that insinuate that he didn't have a good faith basis of making a claim since he's speculating on it? Well, Your Honor, the question was, as you are sitting here today, do you have this information? If the court would like me to reword this here, there's a mischaracterization of what exactly that tweet did in and of itself. Mr. Mignogna has testified on multiple times today that it wasn't just the tweet, but that is a factor that is part of what went into the decision making. The characterization made by opposing counsel is that the tweet was what did it. That's what but you get to ask him questions too. That's correct, Your Honor. So you can ask him all of that. Okay. But Martinez is bringing up a great point here. Lemoyne is trying, for some reason, to establish that Funimation's tweet, and again, we have no idea why Lemoyne is trying to represent that Funimation's tweet. What Lemoyne would say here is that, well, it goes to this being a frivolous lawsuit against my clients because I'm establishing that it's frivolous against Funimation, which is, one, stupid reasoning, two, bad logic, right? Like, again, if A, then B, A, then C isn't a real thing. That's not how this works. So you don't get to say that if he did it, if he ruined or if he frivolously sued Funimation, then he frivolously sued my client. That's not how this happens. But that's what he's trying to do here. Mr. Mignogna, as we sit here today, can you point to any evidence to the court that Funimation did anything to interfere with any of those conventions listed in Exhibit 9? I have no specific evidence, but I was told by certain people involved with certain conventions that there was involvement by Funimation. There you go. Move Exhibit 9 into evidence as demonstrative, Judge. No objection. All right, Exhibit 9 is admitted. Mr. Mignogna, please look at Defendant's Exhibit 16. We got 4 pages left. It's up on the screen. Have you ever seen Defendant's Exhibit 16 before? I've not seen the printed version of this, no, sir. Okay, if you would look to the very last page of Exhibit 16, isn't that your written signature on Exhibit 16? Yes, sir. It is? So, this soft A, I can't express this enough. I'm inferring here, this is Vic Mignogna's either affidavit or unsworn declaration. Now remember that Low T Greg Idiot has suggested that Vic's signature was photoshopped onto this paper. Again, alleging egregious misconduct by Ty Beard. That he forged the signature of Vic Mignogna on a document submitted to the court. Not just an improper notary, mind you. He's alleging, T. Greg is alleging that Ty Beard forged his client's signature via Photoshop based on a retarded person on Twitter saying that they determined that to be the case with no listing of expertise, no indication they would have any idea how this would happen. Okay? Other than I matched it up in Illustrator or something and it looks like it's a Photoshop. That's what Lemoyne is going off of. For all of Lemoyne's bullshit about me being an agent of Ty, Lemoyne is taking a literal idiot's argument from Twitter and suggesting this to Vic Mignogna right now. That's what's going on right here. And Vic is BTFOing him. Is that your written signature? Yes, sir. It is? Yes, sir. He honestly, this stupid idiot, honestly thought that the signature was forged. He honestly thought that. Where were you when defendant exhibit 16 was signed? I don't even remember. Well, it's August 30th, 2019. Does that ring a bell? No, sir. Were you in Tyler, Texas on August 30th, 2019? Objection, Your Honor. Relevance? This idiot is trying to establish a fact, one, that is irrelevant, and two, that is objectively stupid. Again, without evidence other than an anonymous idiot on Twitter saying that this happened. Based on... Lemoyne can't even tell who sent this to him. He doesn't even know the person. And he's basing his argument on it. It's a bold strategy, Cotton. Let's see how it works out for him. Yeah, I'm kind of wondering that too, because I think the purpose of this hearing is to determine your attorney's fees and any sanctions for filing the lawsuit, not necessarily this affidavit. If you'd like to have a hearing on sanctions for this affidavit, we can have that hearing, but I don't think that's scheduled today. I think you're going to try to say that he wasn't there in the room when it was signed and they filed this affidavit, and that's wrong. And I appreciate your argument on that, but that's not what we're here about today. If you want to have that hearing, set it. Okay, well, I was really trying to lay... It's both. I was trying to lay the consulates, the predicate, to introduce it into evidence. I mean, it's in the jacket, right? I mean, it's filed with the court. Oh, you withdrew it. That's right. Okay. So you're going to put this in? So I'm going to, but not just for that. I've got a question once I lay the predicate. Wait a minute. Is Lemoyne going to, is Lemoyne... Is Lemoyne going to introduce to the record the affidavit that was withdrawn? Please God. Is this the withdrawn affidavit that they don't want in the record? Okay. Okay. Stick with me now. The withdrawn affidavit that they don't want in the record. Is Lemoyne going to introduce this affidavit into the record right now to the court? Okay. All right. Okay. If they want to stipulate that it is, I'll move 16 in evidence. I don't think anybody is disputing that he wasn't there when he signed it, or that he wasn't in Tyler. We moved to put defendant's exhibit 16 into evidence. We object to this, Your Honor. As Your Honor stated, the purpose of this hearing is to determine fees and or sanctions available pursuant to the filing. This affidavit is irrelevant to that. No! Martinez! I think you should have let it in. I think you should have let it in. Okay, I'll hold off on the ruling on that for a second. Tell me what you're doing with it. We'll see. I don't know if it gets in or not. I didn't skim this part. Okay, turn to paragraph 19. Mr. Mignogna, you just told the court that some unknown people told you things that Funimation supposedly did something. My question for you is, as of August 30th, 2019, you cannot identify any unknown person that any of the defendants had done anything to interfere with any of the conventions, could you? I'm sorry, please restate that. Oh, back up. Paragraph 19 is your description of the bad things that people did to cancel the conventions, correct? Yes, sir. It doesn't identify any human being that you talked to, isn't that correct? No, sir. I did speak to people. All right. So, no, it's not correct. I did speak to people. All right, turn to paragraph 24. Who is Faisal Ahmed? He's on staff with a couple of events. KawaiiCon and Anime Weekend Atlanta are two. He's a guest relations person, I think, for those events. Is he the CEO? Is he the CEO of KawaiiCon? I'm sorry. Is he the CEO? I don't know his actual title. And you read his affidavit? No, sir. You did read his affidavit? Lemoyne, oh my God. And you read his affidavit? No, sir. You did read his affidavit? Excuse me? You didn't read Mr. Ahmed's affidavit? No, sir. I was briefed by my attorneys on the affidavit. Okay, so you don't have any position on Mr. Ahmed's statement in his affidavit about not canceling your engagement to Kawaii-Con? With a K? May I read this? Sure. All right. And would you please ask the question again? You just read the affidavit. You hadn't read Mr. Ahmed's affidavit? Not word for word, no, sir. What about Amanda McManus? In paragraph 32, I'm sorry, I've got the wrong paragraph. Yes, sir. All right, do you know who Amanda McManus is? It's not in paragraph 32. I don't. Actually, I don't think I do recognize that name. This is a disaster of questioning planning here. You've heard it said, right, that attorneys ask the questions that they know the answers to. Now, occasionally you fish for an answer. But here's the problem. Did you read this, didn't you? No, I didn't. What? He doesn't know what to do. Do you know who this very important person is? No idea. All right, how about Raymond Lenzer? I believe that's a convention organizer. Do you know which one? I think he's with maybe Comic-Con. Vic shouldn't be answering these questions, in my opinion. I don't really know. Did you ever talk with him about why you canceled your invitation to Comic-Con? Yes, sir. When did you talk to Mr. Lenzer? When? I don't remember exactly. It was a pretty difficult. I was in a pretty difficult state at the time. Was it before or after he gave an affidavit to be submitted? Before. I was scheduled to be a guest at his event, as I'm sure was stated in the records. Ultimately we had a conversation where he told me that he was going to need to cancel me because of pressure and the negative. Mr. Mignogna, you have not had to pay any money to file this lawsuit. Look at this guy. Like, he gets just owned on this line of questioning. He gets absolutely demolished on this line of questioning. Yeah, I talked to him and he said he had to cancel me because of pressure and negative. You're not going to pay any money to file a lawsuit. Oh my God. This guy went into this examination. This has been Lemoyne's consistent problem throughout this lawsuit. Lemoyne is listening to Twitter. Okay? Lemoyne is listening to morons on Twitter. If Lemoyne had listened to me, think about this. This is the real big brain. If Lemoyne had listened to me, his questioning would have been better. Instead of listening to now Lemoyne says he listened to me and Ty and they're revealing all their secrets. If Lemoyne had listened to me and Ty talk about this case, Lemoyne's questions wouldn't have been stupid. That is insane. It's embarrassing for Jay Sean because he was listening to randos on Twitter. People, first of all, he's listening to people like Shane Helberg. Lemoyne is listening to people like Shane Helberg, or that trans addict guy, or T. Greg, or all sorts of. Lemoyne is an expert on anti-slap in Texas. Lemoyne is a TCPA expert, self-asserted expert. He is listening to people who are not experts on how he should conduct his expert defense of something that is in his, not only his practice area, but his admitted expertise. This is the most embarrassing thing I can think of for Lemoyne, is that as an expert TCPA person, he listened to a bunch of not only non-experts, but non-licensed Texas attorneys on how to conduct his TCPA and got it so ridiculously wrong on his theories that he's asking all of the wrong questions in this conversation. And had he just listened to me or Ty, he would have asked better questions. Really pathetic. Really pathetic here. Wow. Anyway, we're not going to go through. Well, we'll finish page 81 here, and then we'll be done. We'll do the super chats and stuff, and then we'll be done. Mr. Mignogna, you have not had to pay any money to file this lawsuit, have you? Objection, Your Honor, relevance. Goes to his ability to satisfy sanctions. He hasn't had to pay attorney's fees, and it goes to the deterrence aspect of the case. This is a whole GoFundMe component of the case. There is no GoFundMe component of the case, Lemoyne. When are you going to learn this? You're so stupid. There's no GoFundMe portion. You've made it up. All right, here we go. Speaking of GoFundMe, we're at $267,413. We've got Joseph Cole, Ben Murphy, John Rogers, Ann Rosendale, Curtis Price, Walden Tolbert, refunded but doubled now. Oh no, they're going to refund that one again. Tyler Reeves, Aaron Boyd, and back to Michelle Moore. Thank you guys for your donations to the GoFundMe. $267,413 raised so far in this case. And I do appreciate every single dollar, even though I get 0.000% of any of it. I get none of this. The defendants would love for me to get a portion of this GoFundMe money. I get zero. Absolutely zero money from Vic, from Ty, from GoFundMe. I get nothing from this. And it's the funniest thing on earth. All right, back to this thing. This is the whole GoFundMe component of the case. Evidence of paying for your attorney's fees, Your Honor, is not evidence of whether he can pay an award. Sustained. And again, I have to point out, Judge Chupp overrules objections with frequency. One of the few he sustains in the entire case. This is bad line of questioning by Lemoyne. He should know it, but he's too stupid. All right, next. Mr. Mignogna, there is a GoFundMe campaign that was set up for you to sue people. Is that correct? No, sir, I wouldn't characterize it that way. It wasn't set up to sue the anonymous bloggers that have come after you? No, sir. Oh God, we're gonna have to wait. We're gonna have to wait. Wait till tomorrow. I will do a live stream tomorrow. We will finish this document. We will finish this document. But if I keep going, we will be here 4 days. And I'm not going to do that. My voice is too tired for that. And it is too late. So let's, blue ball. But tomorrow, come back. Bring a friend. Bring a con slut with you. And have a good time. Let's read through these chats, and we'll wrap up the. I'm gonna pull up the Hangout link, or that was inside the Hangouts is what it's called, but that's just my own personal labeling. Bring up this view. All right, guys. There will be tomorrow the remainder of the reading of this case. 11 p.m. Central Time, just like every other show. Now I'm going to read through Super Chats and Streamlabs donations. So if you do leave during that, thanks for hanging out tonight. Come back tomorrow. Check out the rest. And we will soldier on. All right? Like Lemoyne trying to get up a small ramp, we will soldier on. And Siren Jack, yes, I am going to be on Twitch after this. But that is a different type of show with less talking involved. All right. All right, so the Pie Baker says, yo, Transcript, I'm really happy for you. I'm going to let you finish, but the Pie Baker had one of the best show ideas of all time, one of the best ideas of all time. Thoughts on the idea, Nick? The idea that you presented is very funny. The amount of work it would require for other people makes it a challenge. So I'm mulling it over. New York Gamers Federation says, Transcript hype. Interested in learning exactly how bad this hearing went for everyone. BT Dubs Nick, we're keeping tabs on a certain university incident here in Syracuse. And we hope to be in touch with you soon to share some of the info. DFTBA, CD-ROM 1019. Oh yeah, I can't wait. I never actually got to elaborate on the university incident. Guys, the University of Syracuse had a crazy incident with all sorts of protests and stuff. I bet you didn't hear about it too much because it's so absurd. But I do want to bring you some info on that sometime soon. So we'll talk about it. Bad Dragonite says, Sonic the Hedgehog, born 23rd of June. is Sega's mascot and the eponymous protagonist of the Sonic the Hedgehog series. He's an anthropomorphic hedgehog born with the ability to run faster than the speed of sound, hence his name. Oh, wait, I read that one. I don't think that's true. I don't think that's true. Sonic was a brown hedgehog. If I remember right. Sonic was a brown hedgehog. And then something happened to him which made him faster and made him turn blue. Isn't that right? I think so. We'll have to check. Check me on that, autisms. I don't fully remember. Oh, whoops. All right, back to it. Pixel Palindrome says, greetings from your backyard, Western Wisconsin. I've never super chatted before, but I love your streams and wanted to show my support. As a fellow Midwesterner, I have to ask, Valley Fair or Camp Snoopy or the Wisconsin Dells? Oh man, that's a tough choice. I tend to do Camp Snoopy mainly because it's easier to take my kids to Camp Snoopy, and plus we get lots of, because of shopping at the right time at the Mall of America, we get lots of the free wristbands. So that's a little bit easier and cheaper than Valley Fair. You got 5 kids. Cheap amusement parks are better than expensive ones. They also don't, they don't. Only like one of them is tall enough to ride all the rides at Valley Fair. So, well, that's changing soon. But I love Wisconsin Dells. Lots of fun. But that's all water stuff. Bad Dragonite says, so let me get this straight. Lemoyne's main problem with Nick Rekieta, who he totally doesn't care about, is that Nick is a good journalist with good sources and is fairly good at predicting legal proceedings and motions. Is that accurate, Lemoy? That's the admission. Hated 7 Days to Die says, once again catching up on 2x speed. Happy New Year, everybody. Happy New Year to you, buddy. Jay says, cannot establish agency, therefore parts of the filings like the 8XX words in the TCPA and the 16XX in the motion for sanctions on you and the GoFundMe, which depend on agency, are purely frivolous and brought in bad faith? Ben Cheever says, your 30-second refutation of some Trump derangement idiot on his ideas of what the president, though specifically Trump, because he wouldn't say poop if it were Obama, was a flash of the brightest content, in my opinion, that you do on your channel. More law, please. Well, yeah. Okay. Gotcha, buddy. Senpai is homo. Says, how can you uninvite me? You can't silence me. Don't you know that autism speaks? I would never silence you. I would never silence you. S. Cybertaz says, lemon party at the hearing. This is fine. This is fine. And then Cybertaz says, these are all from Cybertaz. Lol, what? Says, a brain slug does not make for a good hat nor hearing prep. When you talk about satisfying fees but can't even satisfy a mosquito, when Lemon Party realizes having Vic on the stand wasn't a good idea, this is fine. All right, back to the super chats now. Gawker's Death Rattle says, throw a coin to your transcriber. There you go. Quantum Video says, what is the worst and best case scenario for Vic's case? And if we win the appeal, will the case get a new judge or will it go back to the last one? In reverse order, it will go back to Chup. Although there's this weird thing. Chup is trying to become an appeals judge. There's a weird possible scenario where the appeals process takes long enough that Chup goes to the appeals court and then a new judge is appointed in his district. And then it goes back to the new judge if they win on appeal. Chup would not be able to hear the appeal of his own case. He would have to recuse himself, although it probably wouldn't be assigned to him anyway. But it is theoretically possible for Chup to go to the appeals court prior to the case going back to him in various ways. The governor could appoint him. I don't know if Texas appellate judges are elected, but Chup does want to be an appeals court judge, from what I'm told. And so it's possible that that scenario plays out. But generally speaking, it would go back to Judge Chup. And that's okay. It's actually okay. Judge Chup has been, he ruled poorly against Vic, and I think he was wrong, but I don't think he was maliciously bad about it. And he ruled negatively against the defendants here. So, it's kind of even at this point. The rest of the question, worst case scenario is that, the worst case scenario is that Vic loses on appeal, Lemoyne wins on appeal, and they maximize the payout. It's extremely unlikely that both of those events occur. Best case scenario is Vic gets the decision overturned on appeal and it goes back and they get to hear the rest of it. So, so there you go. Quantum Video says, Vic lol damn spell checker. Ron Type says, hi there. Be sure to stock up on Bruce Wayne's antidote. They might not be enough to counter the Joker gas called Transcript and die laughing. Green Bullet Prod says, welcome back to the vault. Sadly, I spent my holiday sick. Me too, buddy. And now it progressed to bronchitis. It's been a rough week and I have a real Limois voice. My voice is wrecked over and over. You should hear me in the mornings. It's terrible. Pingus Pounders says, for every $1 donated to SIDS for Kids, Monica or Jamie will sneak into a maternity ward and flash the infants. Oh, that would cause SIDS. Glitchmod says, you working with Davy Crocco against Vox? No. Davy Crocco has sent me information about the Vox situation, and I have not had full time to look into it, but I'm going to try and get some more information about it. So, Weirdo with the Cello says, Lemoyne is an insult to CPAP machines. Almost makes me want to take the mask off and suffer through my sleep apnea instead of being associated with him. Don't do that. Don't do that. Queen Nida says, Senpai is cringe, SMH. Angel Rin 89 says, Senpai is a massive fig. So there you go. Enter the QB says, can the amazing Lucas be a potential guest for you? I read this earlier, but yes, hoping to set that up soon. Austin Heartless says, Lemonhead files so many motions because he lacks the lung capacity to be athletic. Skagi Onsai says, Lafroig select tonight for the transcript. #we. Good luck, buddy. Angel Rin 89 says, what's this I hear about KF finding out JMK is a P to the E to the D to the O? Well, he posted on a pedo help forum, allegedly. He allegedly did, as revealed by S. Cybertaz and the Kiwi Farms as well. Not S. Cybertaz, Spectre. Sorry, I got my S's mixed up. As revealed by Spectre and the Kiwi Farms, he allegedly posted to a pedo forum about wanting to touch his sister or having actually touched his sister when they were a little bit younger. So who knows? Evo Kov says, hey, Nick, you hear about NBA having sex with his daughter? Please, dear effing Christ, tell me that's fake. RJK says, I'll pass it, but I don't. One is a family friend of Chup. I'm your best for off the record, sadly, but I will pass it. Just don't get your hopes, sir. Sorry. Well, RJ, please, if you're still there, please email me. I would love to talk to you too. Coltagon says, I get a Pelosi vibe from Lemoyne. Talbot Link says, just popping in for a bit to throw some change at you. Hey, thanks, buddy. I'll be catching the replay like the lurker I've been lately. Happy New Year, dude. Hey, Happy New Year to you too, Talbot. Some nobody says, Nick, it's 200 pages. You're going to F your voice. Stop. The Lemoyne voice actually doesn't hurt my throat. It's how I do it. It's in the way that I do it. It's all in the breath, and it's not actually hard on my vocal cords themselves. The vocal cords don't get the strain from Lemoyne voice. They actually get more strain from just me talking. It's very weird, but just trust me on that one. Chris Lemon says, I got a preview of this from Hero A stream. Dude, you're going to lose your voice from the Lemoyne impression or laughing. Either way, good luck. TLJ Screwjob says, asking an autism, Nikki, or Nick, any mosquito get to you? No mosquitoes. Nick Corvello says, here's the approximate amount for green tea and cough drops from the thrashing your voice is done with that Lemoyne impression. Surprised you can talk. Raycoon86 says, Happy New Year, Nick. This is the first live stream in a while. Hope you're having a good night. I am having a good night. Almost always having a good night. Some nobody says, Big Dingus Lightning Dragon Law and Associate. Ahmed, the Uber driver, says, a reasonable fee is what I charge to my passengers. Cashew Matthew says, Nick, I'm that guy who keeps asking about interviewing you. I was wondering if you would be available for that interview tomorrow. I will try and respond to you tonight. Yes, I think we can work it out. I have a blank schedule tomorrow, so anytime works for me. Yeah, I'll try and respond to your email. Bad Dragonite says, the next cooking stream, racket soup and nuts. The next cooking stream is going to have a roux. Since you slackers think I can't do a roux, I will prove you wrong. Lunar says, first time catching a full stream during instead of after in the last 4 months due to work. 30 days of leave was a blessing and a curse. Also, welcome back to the Roaring 20s 2K Boogaloo edition. Hey, thanks, buddy. Welcome to you as well. Esme Illis Anime says, Nick, you're missed. Take banana stand money. There's always money in the banana stand. Finfrog says, all your fees are belong to us. Ricky1186 says, here's some New Year's scraps, Nick. Enjoy. Thank you. Chris Lemon says, confirmed that the Wheezing Wonder actually included watching your stream in the billing. So remember, Nick, the longer your streams go, the more money Monica and Ron lose. Wink, wink. They've dedicated tons of money to me already. Whether within their discretion or not is a remaining question. Jay says, so far this is, hello, fellow expert. Hi, expert. Your time's worth this much? Yep. Wheeze. There you go. White Crow says, hey, Nick, have you tried Screwball peanut butter whiskey? It's better than it sounds. I hope so, but no, I have not. I hope it's better than it sounds. Ben Frail says, would it be liable to say Epstein was a predator? It's hard to say. There's a lot of evidence for Epstein being a predator, including people saying that he was, including, it depends on the details of his immunity deal that he took and stuff like that. So, but he's dead. You can't defame the dead. So no, you can't libel the dead, generally speaking. So unless you think Epstein is still alive, which I don't think most people think he's still alive. I think they just question the status of his death. Darkman McEdgeface says, Nick, don't forget to check your email. I read your email, and I'm going to respond to you in the affirmative. I'd love to come on your show. Kalinka Pavlova says, Lemoyne's TCPA strategy is so complex that he racked up costs when the TCPA is supposed to avoid extra costs. Absolutely. Finn Frog says, my PowerPoint was amazing. Lemoyne ass 2019. Evo Kov says, hey, Nick, NBA also slept with his daughter's best friend while she was drunk and unconscious. Please let this be fake. Please let this be fake. Why are you saying this? Isn't this rape since she can't consent while passed out? I mean, yeah. I saw this on a Kiwi Farms and Anime's 9000 channel. Look, I don't know. If it's true, really, really horrific. I don't know how they verified that or found it out. So please, God, let it be fake. Look at him. Those poor girls. Bad Vibe says, objection. Lemoyne doesn't have the lung capacity to suck this hard. Seriously, though, how does Lemoyne not need a short bus to take him to court? Oh, he has one. Sakagi Onsai says, Lemoyne says $500 for oral. What does anal cost? You don't want to know. William Nape says, Lemon Boy is an idiot. I would rather represent myself in court. Better a fool than an incompetent. Fatal System Error says, off to bed. I'll watch the rest tomorrow, or technically today. Good to see you back in the vault. Enjoy that sci-fi masterpiece I hope you got. Oh, and Happy New Year. Did you send me Armitage 3? Or did you send me the books? I don't know which one it is. I got a couple gifts. I didn't go over them on this stream, and I won't go over them on tomorrow's stream, but we'll do them very soon. We're not doing a specific stream for documents. William Nape says, missed my earlier super chat. I didn't miss it. I do $20 plus ones immediately, and I do the rest later so it doesn't disrupt the flow of the show too much. Some nobody says, get to the part where he goes ape poop about me. Well, I'm sure it's going to get worse. No one important says, I'm convinced Lemon is autistic if he is letting outside factors like internet anons and some YouTube guy outside this case influence his case. Walrus Aurelius says, are sanctions permitted under the TCPA? Yes. Jared says, does TCPA award fees and sanctions? Yes. Vladimir M. Ivanovic says, can sanctions be awarded under TCPA? Yes. Freighter J says, are sanctions awarded under the TCPA? Yes. Some nobody says, he billed Monica here whole C-team night stripping. Gross. E1337 Neo says, okay, Nick, here's $3. Do it. Yes. TCPA does award sanctions. It does. It's affirmative. It's in there. West Nile Chin says, do you get sanctions under TCPA, Nick? Yes. At Zuma 99 says, here's your $3. I should have said for $100. Dang. Vale says he's going to need a Senzu bean for that one. Dark Foxen says, mayeth thou receive sanctions under the TCPA, Sa? Yes. Yes. Unbeknownst TX says, curious, can a judge levy ethics complaints or sanctions for frivolous billings and incessant filings? They can recommend a lawyer to the discipline or to the ethics board. It'd be a stretch on this type of stuff. Some nobody says that thing hasn't ejaculated since at least 1993. At Zuma 99 says, I slightly disagree with your definition of insanity. It's not my definition of insanity. In my opinion, I think the definition would be Lemoyne simply existing. Oh, yeah. Well, no, I'll acquiesce to that. You have the superior position. Pro Euro All Might says, wow, who knew Chair Kuhn was an anti-Semite? It's tough, but it's true. Digital Zero says, hey, Rackets, really use some prayers. The wife and I lost the baby last week. Been there with you, buddy, 3 times. Will do. Thank y'all got all the love when I announced to the chat a couple months back. It was really appreciated. And I'm sorry to hear that. I really am. It's never easy. Parochial Joe says, if the Lemon Führer asked to be on the show, would you let him come on? Yes. Yes. RM was here, says, Shane and Ren, birds of a feather spurred together. Those are big birds. S Cyber, and that's a fat joke. Renfamous is fat. So is Shane. S Cybertaz says, Tina Fett was too busy watching The Mandalorian. Some nobody says, Lemoyne literally tried to Bugs Bunny Vic to answer. Joral Navarro says, hey, Nick, awesome stream. When you have the time, can you look up Mignogna versus Forefront Communications? KV is using that as a gotcha that Vic lied about his litigation experience. They're using that because they either don't know or are stupid. But to compare Vic Mignogna versus Forefront Communications to this case, it would be insane. I believe there's no motion practice, no hearings, no anything. Actually, in the Forefront Communications case, it was a filing was done, yes, but it was settled almost immediately between the parties. So maybe someday that story will get told. It's not my place to tell it right now, but they can use it as a gotcha all they want. But if you asked Vic if he brought a suit that was like this one to court against Forefront Communications. I'm pretty sure that case never saw a courtroom ever. So on its face, that's silly. But these people are either uninformed or disingenuous on a lot of things. There you go. But that is, you know, I do hope that story gets told at some point, or that I get permission to tell that story from the people who know about it. I'll see. It's a great story. It's an amazing story. If you don't know the story, it's really cool. Never had any idea about it, but the story is really cool. It's a great story for Vic. Very interesting dispute that happened there. Some nobody says, notice Chup reprimanded Martinez leading on cross. I didn't read that specific section, but we'll get to it tomorrow, I'm guessing. Syndicate Chief says, Wild Thing and Excalibur at Valley Fair is awesome. They're okay. See, I grew up in Houston with Astroworld, and so the Texas Cyclone was my jam. Wild Thing and Excalibur are not the Texas Cyclone, nor are they Grease Lightning. Now, I know Astroworld is gone now because of all of the gangs or whatever, but they will always hold a place in my heart. My first concert, by the way, was Air Supply. I was really young, and it was behind Grease Lightning at Astroworld. An absolutely fantastic Six Flags park. But someday we'll talk about Astroworld. Also, my first haunted house with the real Freddy Krueger at Fright Night, which is awesome. Okay. As Cybertaz says, don't compare me with Spectrum. As Cybertaz says, I'm on the spectrum, but my autism isn't that bad. Bad Dragonite is looking forward to Sonic movie appreciation stream. No. And then finally, KMac 8190 says, love that I'm turning 30 this year. Keep fighting the good fight, Nick. You're a good egg. Have a great year. Hey, you too. 30's a blast. And then finally, Ben Cheevers says, I'm so far behind, but Martinez is an effing savage. Please get him on the show. Get Ty to get his boys on the show. I would love to have Martinez and Only on the show. We'll see. We'll see what happens as we go on. But, all right, guys. Thank you all for hanging out with me tonight. Let's get this. We have an outro. Oh, just a second. Got to change a setting. I'm going to change a setting. Do an outro. This one. Oh, yeah, there it is. Whiskey drinking lawyer. Here's the outro. I've been missing it during my travels. Next time I'll have to bring a stream deck with me. But come back tomorrow. Tune in tomorrow. Or the next round, we're going to finish up this document. Also, double check that you're still subscribed, because YouTube loves to unsubscribe people from the show. And even though they say they don't, they do. And it's amazing the difference in how this works out. So make sure you're still subscribed. Also, check out the video I did earlier today if you didn't get a chance to watch it yet. All right, guys. It's just a brief status update on the case for Vic. There will be one against about Meyer coming out soon. Meyer versus Wade coming out soon. And we've got more short videos coming in the near term. All right. Love you all. Thanks for hanging out with me tonight. If you want to come meet me on Twitch, go ahead. I'm going to go grab something soothing for my throat. We'll be on Twitch for a little bit. Not sure exactly what we're playing, but it's going to be fun. And oh yeah, probably Killing Floor. I think it's going to be Killing Floor. I missed your $20 super chat. I'm not going to miss it. I've got it. I'm so sorry for missing it earlier. The Nerdiest Geek says, after listening to your Lemon voice acting for so long, if I ever hear Lemoi's real Lungless croaking, it's going to sound fake. You'll make a more convincing Lemoyne in the anime. You can hear it actually on the Deposition live stream with Vic. He did the questioning there, so you actually can hear it. So. All right, guys. Check out on Twitch. Asia Fraser says, we tell you what to say all the time. I'm telling you what to say right now. All Ty has to do is make enough super chats to fill your whole show. Yeah, no kidding. All right, guys. Thanks for hanging out. Have a good night. I'll talk to you soon. Peace. Peace.
So pour out an art bag of balm or a love rug. Spirits flow as the ones who get unemployed. So pour out a glass for the tea. Post on Twitter as we hear Lost Blaming tonight. From the white shores of Nan to the hills of Glenlivet, there's no one who explains the wrong better than Nick. So pour out a glass for the ones who have passed to make the law what we have